you say anything to her, she's real quick. She'll say, I don't want you going out. Don't worry about it.
And now, 7:13.
Yeah, her husband's had some health issues. They thought he had cancer, but it turns out he's just got really bad arthritis. Thank God, really. Better that than bone cancer.
Okay, we have our reorganization.
Than bone cancer. With everything else he's going through.
Okay, we'd like to open nominations for chairman, and I'd start it off by nominating Frank O'Donnell.
And Al, if you could just state your name for the record.
Oh, Al Muhammad, member of the zoning hearing board. Nominate Frank O'Donnell as chairman.
Second that nomination?
Do I hear a second?
Charlie Ogle, and I'll second that.
All in favor?
All in favor? Aye.
And he said aye. And our,
I would just note for the record then that Mr. O'Donnell, by unanimous vote, has been elected.
We can't hear at all.
I would just note for the record that Mr. Frank O'Donnell has been elected chairperson of the Eldred Township Zoning Hearing Board by unanimous vote.
and to continue, I nominate Chad as our attorney for the zoning hearing board. And we need a vote for that.
I'll second that motion.
Charles, okay. Voting is unanimous.
I can't see close up. You can't see far away. So
And I'll just note for the record that Chad Martino is nominated for the solicitor. That was seconded by Al Almack. It was unanimous to have me, Chad Martinez, as the solicitor for the Eldred Township Zoning Hearing Board. Now, the next order of business is the application of Nestle Waters North America, Inc. for special exception. Did everybody hear my request that you please sign in? Well, actually, let me just first ask, can everybody hear me? Okay, I see a hand. Is that a yes? We're good? Great. If at any time you can't hear, you can't see, please raise your hand and let it be known. Obviously, it's a public meeting. We want everybody to be able to hear the proceeding. We want everybody to be able to see the exhibits that are being presented, okay? And we don't necessarily know whether or not you can hear or see, so you have to let us know that. Thank you. So as far as the procedure today, this is going to be, and we're going to start the process of having a hearing on the application of Nestle Waters North America, Inc. on their special exception for the water extraction operation. As far as this hearing is concerned, there's going to be some procedural things that happen first. I'm going to make a record with respect to the advertisement of this meeting. And then once I've made a record with respect to advertising and posting of the property, etc. for the meeting, we're going to then identify the parties. And obviously we have Nestle represented, we have the township, we have this gentleman, Mr. Preston?
Yes.
So we have Mr. Preston present, and we will then address the other issues with respect to people. I have the applications here for the people who are interested in entering appearance, and I have the applications. If there's any more, I would ask that you please bring them forward. All right, I see one there, sir, and if you just hold on to that for a minute, and I'll ask again, okay? And the way the proceeding is going to work is that I'm going to put the exhibits in for notice. We're going to introduce the parties. We're going to go through these applications. I believe I do have a motion already from Nestle with respect to a motion for recusal. We'll address that. And then, like any other hearing, what's going to happen is the applicant is going to have an opportunity to then put their evidence on. And the evidence is rather voluminous. It's going to take a while for them to do that. It's my understanding it may take several hearings. So the applicant will introduce evidence. At the end of certain witnesses, there will be an opportunity to cross-examine those witnesses, and the cross-examination will be done by the attorneys for the Board of Supervisors, attorneys for the objectors, and then any other objectors that have standing in this procedure. And we'll go through that process until the applicant has presented all of their witnesses and presented all of their evidence. And like I said, that could take several hearings. It's certainly not going to get done tonight. Then the Board of Supervisors is going to have an opportunity to introduce evidence. Their witnesses will be subject to cross-examination, and so on. With respect to the objectors, they would be able to introduce evidence. Now, if you're an objector and your appearance is noted for the record, you will then have an opportunity to cross-examine witnesses, and you will also have an opportunity to introduce evidence. However, that won't be tonight, and it may not be at the next hearing, and it may not be at the next, because the procedure requires that the applicant introduce all of their evidence first, and then the township will introduce evidence. So it may be a while, but we will continue and adjourn this hearing until future dates are certain. People will have notice of that date, and you can come back, and ultimately we will get through the process of introducing all of the evidence, not only for the applicant, but for the township and for any objectors. And like I said before, if it's a matter of public comment and you're not looking to introduce evidence, but you would like to comment, you will have an opportunity. Now, that's not going to happen during the introduction of evidence, all right? That will happen at the end of the evening. I'm going to set aside some time at every hearing to allow for public comment, all right? And we'll go through that process, but obviously we have to be able to conduct the hearing and also take comment, but it has to happen in a pretty orderly manner so we can accomplish this. And then ultimately, once all of the evidence has been received, the board will review the evidence. The board will vote on whether or not to grant the special exception, and then the board will have an opportunity, and I as the solicitor will draft a decision and a recommendation. It may be to deny it, it may be to grant it. If it's granted, it probably will have several exceptions to address concerns that were raised and other issues with respect to testing, etc. So that ultimately, that decision will get issued 45 days after the last evidentiary hearing. With that said, I'm going to then get into the proof of notice and publication for this evening's hearing. I would ask Ann Polchek if you could please come forward and be sworn.
Raise your right hand, please. You do solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Now, this is Bell Polchek. I'm going to show you what's been marked for identification as Commonwealth Exhibit 1. I'm sorry. Board, Commonwealth. So that's the Zoning Hearing Board Exhibit 1. Do you recognize that?
Yes.
Is that the proof of publication for the reorganizational meeting? And was that published on February 10th and February 17th in the Pocono Record? Okay. And is this a true and correct copy of the proof of publication that you received from the Pocono Record?
Yes.
Right. Now I'm going to show you what's been marked for identification as Zoning Hearing Board Exhibit 2 and ask if you recognize that.
Yes.
And is that a proof of publication for the application of Nestle Waters North America, Inc. for a special exception?
Yes.
And was that also advertised in the Pocono Record on February 10th and February 17th? And is that the original document, the proof of publication that you received from the Pocono Record?
Yes.
You post the municipal building? And now I'm going to show you what's been marked for identification as Zoning Hearing Board Exhibit 3. Do you recognize that?
Yes.
And is that the notice of public hearing with respect to the application for special exception of Nestle Waters?
Yes.
And did you post that on the board of the municipal building?
Yes.
And did you post it anywhere else in the municipal building?
It's interior board of the municipal building, exterior board, this week it's on the door, and it's also posted in the post office.
And when did you cause the board exhibit 3, the public notice, to be posted at the municipal building?
Yeah, I believe February 6th was the posting.
And has this been posted on the municipal building, on the bulletin board for at least the last 2 weeks?
Yes.
I would move for the admission of the zoning hearing board exhibits 1, 2, and 3, which are the proof of publication of the reorganization, the proof of publication of Nestle's application, and then the public notice which was posted at the municipal building. Is there any objection?
No objection.
Thank you. Mr. Helm, you be sworn, please.
You do solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
I'm going to show you what's been marked for identification as a zoning hearing board exhibit 3, which is the public notice for the application of Nestle Waters Inc. special exception. Do you recognize that document?
I do.
And did you, well, what is your role with the township?
I'm the zoning officer.
Okay. And did you cause this public notice to be posted at the subject property?
I did. I posted on several locations. I have the days and dates here in which it was done.
Okay, if you could please tell me the date that it was posted and where it was posted and the manner in which it was posted.
It was posted 2/10/16 at the site itself. It was nailed permanently to the tree on the entrance to the property. I also posted it here in the window in the entrance to the firehouse building here on the same date. And on 2/10/16, it was posted at the township building in the bulletin board and also on my entrance door to my office, the zoning office. Okay?
Yep, thank you. Thank you. The only other exhibit at this point is with respect to any recommendation from the Planning Commission. The board has not received anything as of yet. However, I'm just going to suggest that the record be left open to receive the recommendation of the Planning Commission during the pendency of this proceeding. And is there any objection from the applicant to leave the record open to receive the recommendations of the Planning Commission?
Members of the board, given the provisions of your ordinance which allows the planning commission to submit comments prior to the time of your decision, we do not have an objection.
Please use the microphone.
Can't hear.
Before the next meeting, we're going to get another microphone in here. To reiterate what I said, under the terms of your zoning ordinance, the planning commission is allowed to submit their comments before you make a decision. Therefore, we do not have an objection to their submitting their comments during the pendency of these hearings.
Mr. Martinez, board, we have no objection.
No objection.
Thank you. At this point, I have, is there, if anybody wants to run out and buy some microphones real quick, that would be appreciated. All right, does anybody else have any forms to enter their appearance as an objector? Thank you, sir. Anybody else? All right.
Got one in the back.
All right. Absolutely. Were there any more coming forward? Is that it? Do I have them all? Okay, so what we're going to do now is I'm going to have the parties enter their appearance, identify themselves for the record, and we'll start with the applicant, and then we'll go to the Board of Supervisors, representatives, and then Mr. Preston. And then I have all of the applications to enter your appearance. What I'm going to do is we'll do these one at a time. I will apologize for my mispronunciation of your names as I go, but we'll do them one at a time. I would ask that you please come forward, and then the applicant and the board will have an opportunity to ask you questions, as will I, and then we will make a determination on each of these to determine whether or not legally you have standing to proceed, to take part in these proceedings.
Members of the board, I'm R. Timothy Weston of the law firm of Kirkpatrick, of K&L Gates, and I represent Nestle Waters North America.
Board, this is Tad John McFarland, also of the law firm of K&L Gates, and I also represent Nestle Waters North America, Inc.
It won't go that far. It won't go that far. It's court.
I'm Mark Wolf. I'm a lawyer in Stroudsburg, Pennsylvania, with the firm of Newman, Williams & Michigan. I'm representing Gower Estates LLC, which is a co-applicant in this matter. And with me is Robert Kidwell, who is also a lawyer with the law firm of Newman, Williams & Michigan.
Good evening, Board. Mark Freed from the law firm of Curtin and Hefner for the Eldred Township Board of Supervisors.
And Jordan Yeager, also with Curtin and Hefner for the Board of Supervisors.
Jim Preston. I represent Clint and Donna Deal, Arlene Dunkelberger, Paul and Lisa Lamonaco, and Christopher and Vernon Barley.
Mr. Martinez, has Mr. Preston's clients filled out forms so that we can ascertain whether they have standing?
Have my clients filled out forms?
Yes.
I don't think so. I'm not sure I understand what you're...
Well, if certain individuals are appearing as protesters, and I understand that you represent 4 individuals, then we need to know the background of their claiming standing in this matter.
I'd be happy to give that to you. Okay, do you mind if I sit down?
Go ahead. I want to refer to my notes here. Let's deal with Christopher and Vernon Barley first. They own property that adjoins the Nestle site, so I believe that they have sufficient interest for standing.
And we have no objection to standing of a party that is immediately adjoining, so we agree.
And appellants Clint R. and Donna M. Deal, Arlene Dunkelberger, and Paul and Lisa Lamonaco also own property within the vicinity of the site. However, more importantly, those individuals are appellants in an appeal of this township's zoning ordinance. It was filed on December 17th, challenging the provisions under which this application is being brought. That appeal was filed prior to this application being filed here with the zoning hearing board. I believe the applicants are proceeding at their own risk, and I believe that, and I would like to enter this into the record, but I think it's going to become important later. It's a copy of the appeal that was filed, and I believe that on the basis of that appeal, that my clients have standing. And before I finish up here, I was given a memo that I think Attorney Weston prepared, or someone in his office prepared, and it purports to talk about standing in front of the zoning hearing board. And I believe that was handed to the other parties here and to the zoning hearing board itself. I believe that you had that. and with all due respect, I think it's just flat out wrong. It talks about persons aggrieved. Now, persons aggrieved, there's actually two types of persons under the law. There's persons affected and there's persons aggrieved. Persons affected by the application have a right to appear before the zoning hearing board as a matter of right, and any others may appear at the discretion of the board. They don't have to get up and prove to Mr. Weston or Nestle that they are a person aggrieved. I believe the aggrieved standard comes and actually comes into being based upon a decision of the board. So a person who is affected by a decision of the board in the ways that are described in this memo, that is a direct, immediate, substantial impact, I believe they would have to meet that test in order to be a person aggrieved. Persons aggrieved are those individuals that would take an appeal of a decision of this board. We need a decision of this board for the person to be aggrieved. We haven't gotten there yet. I noticed in the memo, well, actually, Mr. Weston concedes that persons owning or residing on lots that share a boundary with the Gower Estates are permitted to intervene. I do appreciate that. Persons owning or residing on lots within or nearby the zone of influence of NWNA's proposed extraction wells as identified in the hydrogeologic report prepared by EarthRes Group, Inc., contained in Volume 2 of the application. Now, we're being told that persons owning or residing on lots within or nearby that zone would have standing. I believe, I'm not sure where that comes from. This report, I believe, is a report that was prepared by Nestle's expert to support the case that Nestle has yet to bring before the board. That report is not of evidence. The author of that report has not testified. He's not been cross-examined. There's been no impeachment evidence. There's been no other experts called to challenge that. I'm not sure what the legal significance is of the hydrogeologic report prepared by EarthRes Group, Inc. at this point in the proceedings. I think that that's just incorrect. And then the memo goes on to say that any other persons affirmatively demonstrating that they have a substantial direct and immediate interest. That's just, I think, wrong. It's just simply persons affected. What we're doing here is we're mixing persons affected with persons aggrieved. Persons affected can participate in the application, given very broad latitude, as this board probably knows. People participate in these hearings all the time. And in fact, the zoning hearing board is allowed to recognize anybody as a party. They don't have to fall into a report prepared by EarthRes or any of these things. I would suggest that in the case of the bar leagues, they own adjoining property, that in the case of the other appellants that have an action pending in court challenging the very right of these people to be here, are probably fairly considered to be affected by the application.
Board, Mark Freed, I'm not going to repeat everything that Mr. Preston said. I will tell you that I agree wholeheartedly with his comments. Briefly, I believe the position set out in the memorandum from the applicant on the standing is very overly restrictive to what is before the zoning hearing board. The agreed standard is a court standard, not a zoning hearing board standard. And with regard to the zone of influence, frankly, that's, I think, as Mr. Preston said, is gilding the lily. It's essentially saying nobody should be allowed in this case if it doesn't fall within what we believe to be the minimal impacts of, the alleged minimal impacts of our proposal. I will also note that I believe there was some picking and choosing of cases in the memorandum that really focused on no one with any more than maybe 2/10 of a mile having standing, and I will say that I have cases that I can cite to that show half a mile and over a mile where a person that was more than that distance away from the issue at hand was given intervener status.
This is a hazard of having too many attorneys and a microphone. So we'll cut to the chase here, because what I'm going to do is I'm going to then go through the names here, and we're going to find out the specifics of where you live and how far from the impact site and what part of the geological zone you're in, etc. And the attorneys can address that, and then they can indicate whether they do or do not object to your standing.
This is the exhibit that I talked about. If you feel that I want to put in, I can have it marked as 01. Would like to split. What's 01?
Oh, here comes another one.
Mr. Preston, did you provide a copy of that? Did you provide a copy of what has now been marked as Objector 1, Exhibit 1 to Mr. West?
Yes, I.
So Mr. Preston is looking to introduce what's been marked as Objector 1, Exhibit 1, a notice of appeal pursuant to 42 PACS Section 5571.1 that was filed, timestamped December 17, 2015. Is there any objection to this being entered as an exhibit?
Members of the board, on behalf of Gower Estates, we object to the introduction of this notice of appeal and to the argument that the notice of appeal in and of itself grants the party appellants in that matter standing in this proceeding. That appeal relates to the procedures by which the zoning ordinance was amended. That's separate and apart from the issue in front of you, which is a special exception application of Nestle Waters. The issues in that appeal have nothing to do with the special exception. That is a legal procedural issue that will be decided by the court. It has nothing to do with this proceeding and does not confer, in my judgment, does not confer standing on the party appellants just by reason of the fact that they're appellants in that matter.
I don't have to say anything more.
Board of Supervisors, do you have any comment with respect to that? You don't need to respond to it. With respect to this, I mean, I understand what the applicant's saying, and they object to this as not being relevant to the proceeding. However, the zoning hearing board, although we do collect evidence, is not going to be hard and fast rules on collection of evidence. It will be admitted. The weight of its evidence, however, is questionable, and whether it has any direct bearing with respect to the special exception and the ordinance being applied to this special exception, that's what's controlling, not this appeal. But Objector 1, Exhibit 1 is admitted into the record. Now I'm going to go through the forms now I have here from the objectors, and I believe that the first one I have is Vernon and Marietta Barley, which are, they are represented by Mr. Creston.
No, I represent Vernon and Christopher Barley, who own property together. Vernon and Christopher Barley, they own that. It's fenced by the entirety. Is that correct?
Okay, Mr. Barley, if you could, and I know this is awkward with the microphone, and I foresee myself falling over after tripping on this cord, but I would ask that, so Mr. Vernon Barley, if you would please step forward. And you've, I'm looking at an exhibit that's been identified as Barley 1, and And Mr. Barley, is this your application to enter your appearance in this matter?
It's one of them, yes.
You filled out this form, this is your signature?
Yes.
Okay, if you could please explain where your property is located and why you believe that you are going to be impacted by this project.
Well, these properties,
Here, you can speak into the microphone.
my wife, we own a couple of properties that are adjacent to Mr. Gower's site.
Okay, and so they're adjoining and
Yes.
touching the property?
Yes.
Okay, is there any objection to Mr. Barley?
I think, as I said when Mr. Preston was speaking, we had no objections to Mr. Bartlett. He is an adjoiner.
Next name is Patrice, oh, that's a Junta, J-I-U-N, or R-T-A? Jonta, Miss Jonta, are you present? Great. Ms. Jonta, this is your application to enter your appearance? All right, and what is your basis for standing to enter your appearance? Please.
I live on Kunkletown Road, adjacent to the Eldred Township Municipal Building, directly in Zone 2. Contingent, I guess, with them, like, right next in the aquifer, same watershed. Plus, I'm on the proposed truck route out of town with the 40-ton trucks going by my farm.
And how far do you know, could you estimate, is your property from the proposed development site?
Roughly, as the crow flies, maybe half a mile, mile at the most.
Okay. Thank you. And you?
Could you provide us with your address?
I did. 474 Kunkletown Road, adjacent to the township building,
That would be to the west or east of the township?
west.
West of the township.
Correct.
Based on the decisions that we cited in our materials, I believe that this if
please, you are going to want to have an opportunity to address the board. And when you have that opportunity to address the board, everyone, including these attorneys, will be instructed to be quiet and to listen to you civilly. And I would please ask, just so that we can move through this process, that you do the same. You know, I understand that emotions run high, but we do need to address these. And obviously, you know, what one attorney says or the other attorney says isn't going to carry the day, okay? Is there any objections from the Board of Supervisors with respect to this?
No objection, and just for the record, I believe if it's zone 2, it's within half a mile.
No objection.
In light of the fact that Ms. Junta has indicated that she is part of the aquifer that Nestle will be drawing from, and that she is within a mile and also along the route of vehicles that are going to be bringing the water, or the trucks in and the water out, it appears that she would have standing in this matter. You can have a seat. I have what's marked as Exhibit Klein Top 1. Is this your application for standing in your signature?
It is, sir.
And if I see your basis for standing as resident, if you could please give your physical address and its location to the proposed facility, and any other basis you have for standing.
362 Kunkletown Road, Kunkletown, Pennsylvania, probably less than a mile as the crow flies. I have a vested interest owning a section of the Buckle Creek. I'm a 20-year commercial construction professional and an expert in construction, code, and document language. I don't think you need to know more than that.
Where's your property located, east, west, north, south from the proposed facility?
I am slightly to the west. I would be slightly north and west of the proposed site.
Slightly northwest.
Correct.
Okay, and you say your property borders on the Buckawaw Creek?
I own a chunk of Buffalo Creek. My pins are in it.
And do you have, well, I presume you have well water within that vicinity?
Correct.
We don't object to this individual having standing.
No objection? Mr. Kleintop would be admitted as having standing as an objector in this proceeding. You can have a seat, sir. The next name is Megan LeBlond. If you would come forward, please. Ms. LeBlond, I'm showing you what's marked as LeBlond Exhibit 1. Is this your application for standing and signature?
Yes, it is.
Okay, and you could please state on the record your basis for standing.
I have records of Food and Water Watch, the Northeastern chapter, provided to me by the New England senior organizer, Nisha Swinton.
I'm sorry, the name of the organizer?
Nisha, Nisha, Swinton, Swinton.
Am I correct in reading here that Food and Water Watch is an organization out of Portland, Maine?
Their headquarters are in Washington, D.C., and this is from the New England senior organizer, and her location is in Maine.
And the organization then has national headquarters in Washington, D.C.
Correct.
And what affiliation or interest does Food and Water Watch have with Eldred Township or the Buckawaw Creek or the proposed site for this?
It's a watchdog organization that looks over food and water industry. They have a wide variety of causes that they look into and support with data and legal representation. This is a document they provided to me related to a community going through a similar or a water problem or in their town. So
And,
it's an example of a situation that Nestle is a part of.
Are you a member or a designate of Food and Water Watch?
Nisha has produced this document for myself to distribute today. You can see here it is addressed to the members of the Zoning Hearing Board, members of Eldred Township, and the surrounding community.
For the reasons set forth in our memorandum, for an organization to have standing to appear, they need to have members who have a direct connection with this municipality and have a direct connection to this matter. I haven't heard this witness describe exactly where she lives or her distance or relationship to the project, and I would suggest, Mr. Martinez, perhaps an inquiry as to that would be appropriate.
My address is 257 Border Road, Cumbertown, Pennsylvania.
And where is that in relation to the subject property?
It's a couple of miles away. I'm not sure exactly how many.
And are you on, are you on city water, well water?
I have well water. My road, Border Road, is perpendicular to Silver Springs Boulevard, the primary route.
We join in Mr. Weston's objection. We submit that this person has not demonstrated any of the elements needed to demonstrate standing in this matter as established by multiple cases.
The township has no objection and will defer to the board's discretion.
While I have no objection, I'm not sure why we are using the standards set forth in the memo as the standards when they don't apply. They're for parties aggrieved and not parties affected. I'm just confused by that, but no objection.
Well, Mr. Preston, I'll ask you, and then because you don't have an objection, with respect to this application, we have an individual who has indicated that she is essentially a member or designate of an organization that doesn't appear to have affiliation with the local area, but does have an interest in general water and food safety rights, and that she's approximately 2 miles from the impact area. So what basis would you argue, even if you take exception to the memorandum submitted by the applicant, what basis would you state that she would have standing?
Well, before I would do that, I would talk to the young lady, and I would get some information from her. I assume she's on well water. I would correlate that with the appeal. I haven't had the opportunity to do that. So, but more to the point, I think if I were in Mr. Weston's shoes, I believe, based on what this young lady has said, that she probably would not be able to take an appeal of a decision of this board. I think that's the rub. She probably would not be a person aggrieved. But is she a person affected? I mean, quite frankly, the board has the ability. They can adopt any party that they wish to. There is no standard for that. Truth be told, I haven't had a chance to interview the young woman.
Am I to understand then your position would be that if she had access to the aquifer and had well water, it's my understanding that she did indicate that she had well water and lived within 2 miles of the subject property?
I think that would be sufficient for me just to have a party to standing as a person affected, not necessarily a person.
And to follow up on Mr. Preston's point, I believe the municipality's planning code section 908 allows the intervention of any person, including the civic or community organization, permitted to appear before the board. So as Mr. Preston said, it's a much broader than the court standard.
To respond to two of the issues here. First, although she indicated that she uses groundwater, she did not indicate that she's in the same aquifer, and I think it's fairly clear that she is not, based on the geologic studies that have been done. Second, Food and Water Watch, from our knowledge, is not a community organization in this community. It's an organization she reached out to gather some information. I didn't even hear Mr. Martinez that she said she was designated by that organization. I heard that she gathered information from them.
Ms. LeBlanc, where did you get to? If you could come forward. So there's a couple questions for you. As far as your specific designation for this organization, you heard the representation that you know it is, yes, an organization, but what is your role with that organization?
I would just like to be providing records of Food and Water Watch to.
Is it fair to say then that you have information you've generated from Food and Water Watch or received from them, and that you would like to submit that?
Correct.
Thank you. With respect to the statement that Ms. LeBlanc is clearly not part of the aquifer that's impacted by this, I'm not sure how we reach that conclusion. I don't know if the board, at this point, the representatives of the board or Mr. Preston want to address this issue with respect to determining, because obviously that is going to be an important issue of whether someone is or is not within the aquifer that's impacted by this. We have no data at this point to say that she's not in the aquifer. She lives relatively close to the development site and has well water. So.
I see Mr. Preston's hand is up.
The response is that I think you're absolutely correct.
That's why I'm asking the applicant. I mean, at this point, you know, your objection is that she's not part of the aquifer. We have no information with respect to that. Obviously, we haven't taken any testimony, so.
The board could also reserve a ruling on party status to the end if it becomes, you know, if it becomes an issue.
Well, it's either we address this issue and we determine that you know, the aquifer where it is now with respect to the board and the objectives we have now, or we admit them pending this evidence being introduced and making a determination at a further date with respect to the scientific evidence that we introduced.
I think the difficulty this board is going to have is if anyone who has a groundwater well says that they use groundwater anywhere, that somehow they have a connection to this community and a connection to this project, we're not going to be able to admit the entire Commonwealth of Pennsylvania. I think Mr. Yeager's suggestion, if there is a question about whether this individual on the basis of groundwater has a direct and substantial connection, and we can't determine it at this point, then I think the board can reserve its right to determine whether she has standing until that information is on the table. I don't believe that what she has just said about her connection with Food and Water Watch indicates that she, on the basis of that connection, has standing.
Okay, so based on that, and it does become a complicated issue with respect to where this aquifer is. Obviously, the board wants to create a full and comprehensive record with respect to this application, and the board is not inclined to deny someone standing without a fundamental basis to do so. So at this point, we will move forward. We will grant standing pending a determination and collection of further evidence with respect to that issue. And then we will move forward with Albert Barney Jr. Mr. Barney, I'm showing you what's been marked as Barney Exhibit number 1. Is that your signature and on your application?
Yes, it is.
All right, and I would just ask you to please state your basis for standing, and including your physical location and its proximity to the development site.
Well, my physical location has nothing to do with the development site. Why I am here is that I'm the past president of the local watershed group, and I do have information as far as the site directly below it. The County Conservation District tested the area numerous years. I think that data has been overlooked, and I think it needs to be looked at.
What's your proximity to the site?
I'm a resident of Creskyville.
Okay. All right, thank you. And you indicate you're a past president of the Aquashikla Watershed Conservation?
Aquashikla Pohopoco watershed.
Okay, thanks.
With respect to this individual's connection to the community, I don't believe his direct connection merits standing. In terms of the information he has, if someone wishes to call him as a witness and he has information, he certainly can be called as a witness, and that would be, I think, the appropriate way for his information to come in.
Based on some of the comments I made earlier, I believe both the gentleman individually as well as, and more particularly as a representative of the civic organization that is clearly a local civic organization, is entitled to standing in this matter.
I think at this point, frankly, being the past president, he's not the acting president, he's not a resident of the township, there's no representation that he's drawing his water directly from the watershed. I would say that Mr. Albert Barney Jr. does not have standing with respect to this matter. However, obviously, as Mr. Weston indicated, if he does have information and believes that information is relevant, or the Watershed Association itself wants to introduce evidence, that's another story.
The only question I would have, Mr. Martinez, is as well as further inquiry whether or not he's a present member, even if he's not a present officer.
Mr. Barney, where are you? Yeah. And so the question was put forth because you did indicate you were a past president, but are you currently a member?
I'm sorry?
I have made donations to the watershed.
Are you a member in good standing of this organization?
Not as of 2016 yet. I haven't renewed yet.
I'm sorry, I can't hear you.
I haven't renewed my membership this year.
So with your indication that you were a past president, you have not renewed your membership, so you are not currently a member of this community organization, then I would respectfully rule that I don't believe you have standing in this matter. Mr. Hilbert, I have a document here that's marked Hilbert 1. I would just ask that you identify this as being your signature and your application.
Yes, it is.
And
Yes, it's mine.
And if you could please tell the board your address, your physical proximity to the site, and whether or not you draw from this aquifer in your belief.
Kenneth J. Hilbert, 342 Town Road. I'm approximately 1 mile from the fire company here,
And in which direction?
heading towards Little Gap.
Okay, so you're on the far side of the municipal building?
Yeah.
Okay.
I have a shallow well, and last year, about 2 months, we smelled sulfur coming out of our water pipes. We did not taste sulfur, but we smelled sulfur.
And you indicate how far from the site are you?
A little, maybe a mile.
Okay.
A little over a mile.
And you're on well water within the township?
Absolutely. And I have great concerns.
Applicant?
We don't object.
All right. Standing is acknowledged and admitted. And we'll continue to work our way through here then. I think it's Desiree Yakel. Y or J-A-E-C? Did I get it right then? All right. All right, again, if I could just ask you to please identify what's marked as Jacobs 1, and then state your address, your location to the facility, whether or not you're on well water, and any other basis or standing you may have.
177 Church Road in Kunkletown, approximately a half a mile away. And I'm, okay, of course I have well water and I have donkeys and llamas and I'm very worried about.
Well, that's okay. As far as, let's just stick to the facts.
Okay.
So you're approximately half a mile away.
Half a mile away.
You have well water.
Right.
And then where exactly in reference to the site location, the proposed site
Half a
location?
mile.
Yeah, but in which direction?
Over, beyond the cemetery, beyond the cemetery.
Okay. Towards the municipal building.
No, this way, going towards, Broadheadsville.
North.
North. Thank you.
Okay.
North. North.
All right. Thank
I
you.
thought I had to be more descriptive.
No, that's great. Okay. Any objection?
Did you want to say something?
Oh, no, I have a disclosure from the state about property values and that's.
Okay. No. At this point, we're not hearing any
Oh, okay.
basis. We're just,
Oh,
whether
okay.
you have standing
I
or not.
thought that was, I
Nope.
have something specific in my hand. Okay.
Not yet. We'll get to that. Just stay there for a second.
With respect to this witness and her connection to the groundwater, I think we would take the same position as we did with the other witness, or excuse me, the other individual, as to proving the connection being held in abeyance until we have the geologic evidence of record.
Thank you.
What was the geological in this case? It was market property values.
Is that yours? That's not.
That's my husband, he's gonna be here any minute. Can you put that over on? Give it a look. So you.
C-K-L-E. Thank you.
Ma'am, do you have that form?
Yes.
No, right here. Great, thank you.
That's it?
Yep. And your husband, with respect to Rainier
Yeah, he'll be
Jekyll, you indicate that he,
10 minutes away.
and he lives with you, same property location, et cetera.
Whatever the disposition is for the family is the family.
Oh, okay.
He doesn't have to individually qualify himself.
Oh, okay. You tell him that. Oh, boy.
Yes, sir.
Martinez Township believes that a resident within half a mile of the site that uses well water is clearly an affected person that is entitled to stand.
Patricia Tyndall?
What do I hear?
Just Martinez, could you make a ruling on
I did, I'm sorry, just for the record, with respect to Jekyll, there were two, it's Rainier and Desiree, and they have both been granted standing. Ms. Tyndall, I'm showing you what's marked Tyndall Exhibit 1. If you could please just identify that as your application, and if you could state your address, your location to the site, whether or not you have well water, and any other basis you may have for standing.
256 Grove Road, about a half mile north, right near Desiree, right around the corner.
You have well water?
Well water.
Is there any objection? No objection? All right. So that application then is submitted. Thank you, Ms. Tyndall. Vernon Barley? There's more than one. Thank you. Mr. Barley, your application for standing has already been granted, so. Donald DeHaro? Is Mr. DeHaro present?
That's an N.
Okay.
Can we mark that, Jeff?
Yes, please. Thank you. I'm terribly sorry, Mr. Denaro. If you could please state for the record your address, your location, whether you're on well water and any other basis for standing.
Okay. I've owned a piece of property up on the Blue Mountains since 1974. This is a developed lot, and I've been paying taxes on it since 1974. I am at the head of the gradient of the aquifer. And according to Darcy's law in hydrostatic gradients, anybody living up on the mountain could possibly lose their well water. So I'm here to address that situation.
And how far, sir, do you believe that your property is from the proposed facility site?
It's directly on the aquifer. It's directly at the head of the aquifer.
Could you give me a distance, do you believe, that you are from the site?
1 mile.
Thank you, sir.
If we could have this gentleman identify, we have a map over to the left, and if we could bring it forward, identify where his property is located. Sir, I'm going to give you a red dot. You can put it on the map.
This would be the uphill gradient of your aquifer. Mr. Weston, can you give it?
The other one will work.
Thank you.
This would be the uphill gradient of your aquifer. And let's see, it would be somewhere right there. So it's directly in line. Your aquifer runs in this direction, runs downhill right to Gower LLC. So the actual aquifer is shaped like this. I live up in this direction right here, or I own property in that direction right up there at the top.
I'm not going to engage in a debate about the aquifer at this point. The studies we've done is that the aquifer actually goes. I said I'm not going to engage in a debate about the aquifer at this point, even though the studies that were conducted actually show the aquifer going east and west. Somebody turn it up. I will try it again. I will not engage in a debate about where the aquifer is, even though the studies that have been conducted at this point indicate that the aquifer that is tapped by Nestle is an east-west aquifer. I believe this individual lies at the upper end of the watershed, and on the basis of his concern, although we will dispute the concern, we won't object to the standard.
Any objection? So we'll accept Mr. DeNaro's application for standing.
Yeah, no,
Mr. James Lighting. Mr. Lighting, I'm showing you a document that's marked Lighting Exhibit 1. If you could just confirm that that is your application and signature for standing. And then if you could please, thank you, sir, and if you could then please state your address and then its physical proximity to the proposed site, whether or not you're on well water, and any other basis you may have for standing.
Yeah, I live at 379 Church Road. It's approximately a mile and a half north on Church Road. I have a well. I'm also concerned about property value.
I will, for the record, state the same objection we've stated before. And I would note that if there's a question about the connection to the well water, then making a final ruling should be held in abeyance until we have the geologic evidence.
Okay, at this point, we will accept the application of Mr. Lighting. And again, as indicated, to have standing, there will obviously be evidence submitted by the applicant to establish where the aquifer is and may potentially be affected by a draw on that aquifer. And if it's determined that your property is not within that aquifer and you are significantly removed from the development site, and that your well water could not be negatively impacted such that you do not draw on that aquifer, then at that point the applicant has reserved the right to then challenge your standing. And so that is what's happening at this point. And so we will allow, we'll accept his application for standing pending that further determination. The next application is Mr. Charles Phillips. If you would please come forward. Okay, Mr. Phillips, I'm showing you what's been marked as Phillips Exhibit 1, and if you could just confirm that this is your application and signature.
Yes, it is.
And if you could please state your address, your location of the site, well water, and your basis for standing.
358 Fiddletown Road. Not about a mile from the site. And I have a well several hundred feet.
Am I to presume your objection, essentially standing objection pending introduction of evidence?
If we ask him to please state his address again.
358 Fiddletown Road.
Correct. Could I ask this gentleman to mark onto the map? We're going to give him a yellow dot. Mark 2. And if you could just put wherever your property is located. I got it.
No, you can't get it. Oh my gosh. Only here's
Okay, I'm standing behind you, sir. So it is near the intersection of Fiddletown Road and Princess Valley Road.
Right. It's now Smyxville Valley Road, I think, we should change the name.
This witness, I believe, or this individual is a further distance than stated according to that map, and we would pose an objection.
Sir, how far do you believe you are from the proposed site?
Well, I measured it out, and it might be a mile and a quarter at the very most.
And you have well water?
Yes, I do.
And the applicant objects because of the location?
It as even being more distant of those that we.
This is a gentleman whose site is significantly more distant than those that we reserved for review of the geologic evidence.
In here.
This gentleman's site is significantly more distant than those on which we reserved on the basis of geologic evidence.
Any objection? Well, at this point, thank you, Mr. Phillips. At this point, since we don't have any evidence introduced into the record yet as to where the aquifer lays, he indicates that he's a resident of the township, lives within a mile and a quarter, and does have well water, so you will be, at this point, granted standing. Next applicant is Doug Orger. If you would please come on down. Mr. Borger, I'm showing you a document that's with Mark Borger, Exhibit 1. If you would just confirm that's your signature in your application for standing.
Yes, sir.
And if you could please state for the record your address, your proximity to the proposed site, whether you have well water or not, and any other basis for standing.
640 Kunkletown Road. I adjacent the Gower property.
You're adjoining the Gower property?
Yeah.
Mr. Borger says that he's adjoining the Gower property. Doug Borger.
If he adjoins the Gower property, he has standing.
And we will accept Mr. Borger's application for standing as granted. Robert Bush, could you please step forward? Mr. Robert Bush, I'm showing you what's been marked as Exhibit 1. Is this your application and your signature?
Yes, it is.
And if you could please state your address and its proximity to the proposed facility, whether or not you're on well water, and any other basis you have for standing.
I have two properties in the vicinity of the water extraction site, approximately 3/4 to 1 mile away. The first property is 369 Kunkletown Road, which is my home, and we use well water there. The second property is 302 Kunkletown Road, which is my business, which is a personal care home, assisted living facility. We are a community water supplier with the Pennsylvania State ID number, and I am the water and sewer certified operator for my facility. Property goes to the center of the Buckwaw Stream, and we're concerned with issues of water extraction and truck traffic.
And you said that your residence is how far from the proposed site?
Within 3/4 to a mile, 3/4 of a mile to 1 mile.
We don't object to this individual.
Any objection? No objection, then Mr. Bush's application for standing is admitted and granted. Arlene Dunkelberger. Okay, Ms. Dunkelberger, I'm going to just have this marked.
I'd like to assume that they can grant standing just for the purposes of the hearing.
Yes. And Ms. Dunkelberger, you retained Attorney Preston?
Correct.
And this is your signature in your application for standing?
It is.
Is there any objection?
What's the address?
My address is 640 Kunkletown Road, and I am adjacent to Mr. Gower's property.
Since she is adjacent, no objection.
Thank you.
There being no objection, Ms. Dunkelberger's application is accepted and granted for standing. Would Ms. Diana Landeslager please come forward? London Slager. I apologize. And again, I would just ask that, well, I'm going to show you, is this, it's been marked London Slager, Exhibit 1. Is this your application and signature on this document? And if you could just please state your address, its proximity to the proposed site, whether or not you have well water, and any other basis for standing.
254 Chestnut Ridge Drive, Kunkletown. I am within less than half a mile of the proposed extraction site. I feel that I will be affected by the traffic, by the trucks, not to mention my well water, and also devaluation of my home.
Any objection?
Based on her proximity to the site, we do not object.
There being no objection, your application for standing is granted and accepted. But ask that Ramon Baker please come forward.
Is it gonna be a long process?
Yes, absolutely.
Mr. Baker, I'm showing you what's been marked as Baker Exhibit 1. If you would please confirm that that's your application and signature.
That is.
And if you could please state your address and your location to the proposed site, distance therefrom, and whether or not you're on well water and any other basis for standing.
Okay, two things. First of all, I'm within about 2/10 of a mile from the truck route, which is going to go along Silver Springs. And I'm on well water. And I'm concerned that I may be affected because only 2 years ago there was a drought where I am. My wife and I are. And the spring dried up, the pond dried up. And that's part of my concern. I'm concerned also about other items about this process.
You're not that I'm discounting your concerns, but essentially at this point we're trying to determine standing. And so your concerns aside for the moment, how far is your property from the proposed site? Okay.
Watch the court.
Let me just bring these forward.
Could we ask, does anybody have a ruler?
If I could ask Dr. Baker to please put a yellow sticky that says 3, where his property is located.
There long enough. There's enough people out of the way. I don't want to stress anyway.
Okay, let me see if I understand. You've just measured off 7.5 inches, 1 inch equals 2,000 feet. About 15,000 feet, which is about 3 miles, actually 2.5 miles. Thank you, Dr. Baker. We do believe that this individual is too far away from the project to qualify for standing.
Dr. Baker, yeah, I'm sorry, if you could please come forward. I just want to confirm for the record, there's been an indication by the applicant that you're approximately 2.5 miles from the site in a northwesterly direction. Is that correct?
That's correct.
You indicate that you are in well water and you're a resident of the township?
That's correct.
That's correct, sir?
Yes, that's correct.
Mr. Martinez, I would just comment that the location of the site is not the only issue. I believe the doctor mentioned truck traffic and other issues as well.
The despite the objection of the applicant, I would say, again, without having the geological information with respect to the exact aquifer, and then not taking further testimony at this point with respect to the route and the traffic relative to Mr. Baker's property, we will accept his application and grant him standing pending further proceeding in this matter.
Whoever has a black Chevy Silverado that parked down below here, you have to move it.
Perfect timing. All right, Carrie Eckhart, please, if you would come forward. Good evening, Mr. Eckhart. I'm going to show you what's been marked as Eckhart Exhibit 1. If you would confirm that's your application and signature.
Yes, it is.
And if you could please state for the record your address and its proximity to the proposed location.
Yeah, there's
Proximity to the proposed location of the extraction site and any other basis you may have for objection.
I have two properties. 612 and 614, and that's Cocotown Road, which is approximately, I would say, 300 feet from Gowers LLC. I have a shallow well. I believe I'm on the aquifer, plus I can get water through the bucket well. And my property joins Gower on my west.
Hey, speak up, we can hear you. How many times we gotta tell you?
Please, sir.
Please, just speak up.
Please.
People
We
can't
understand to speak up. We get it. Thank you. Mr. Eckhart indicated that he joins the Gower property and he has a well, and he is a resident of the township, lives next to the project site.
I believe he does adjoin the Gower Estates property, and he would qualify for standing.
Any objections? No objection. So Mr. Mr. Eckhart's application for standing is granted. Lisa Lamonaco, if you would please come forward. Ms. Lamonaco, I'm showing you a document marked Lamonaco Exhibit 1. Is this your application and signature for request for entry of appearance?
Yes, it is.
And if you could please state for the record your address, your proximity to the proposed site, whether or not you have well water, and any other basis you believe you may have for standing.
Adjacent to the property, 342 Chestnut Ridge Drive, Crumpletown, PA.
We have no objections.
There being no objection to the request for entry of appearance, we'll grant the application for standing to Ms. Lamonaco. Anyone else? Excellent. All right, we're going to take just a moment. Yes, ma'am.
I turned mine in today to Secretary and Sharon Salt.
Your name, ma'am?
Donna Deal.
Mr. President.
I filled one out today and turned it into the.
Well, I was already gone.
Mr. President. Donna Deal.
She's right on top of the site. joint houses. No, she's on the other side. Her brother Doug is here, Doug Porter. And then there's the thing, and then her house is here. And then he's down there, and he's on the corner or something. And the gal property on the other side. It was deep water rights. Nobody's using it. See, Joe?
Good evening, Ms. Deal. If you would just confirm that this document marked Deal Exhibit 1 is your application for request for entry of appearance, and that's your signature?
Yes, it is.
Okay, you can confirm that it is, and if you could please just state your address, its proximity to the site, whether you have well water, and any other basis for standing.
634 Kunkletown Road. My property adjoins the extraction site, and I have a well.
Is there any objection to Ms. Deal?
No objection.
There being no objections, then we will accept her request for entry of appearance for standing. At this point, we're going to take
A brief question. I had filed out a form this morning for a rating of the standing. Good evening. My name is Ryan Jacob. I'm a longtime resident of Kunkletown. I'm domiciled at 177 Church Road. It's in the Tier 2 extraction zone. Yes. I'm late. I was on a power outage, and I apologize, but I would like to keep my standing.
Yep, Mr. Jacob, we already went over your application, and you have been granted standing.
Thank you very much.
Yep. All right. Any other applicants? Great. We're going to take a brief recess. If you want to use the restroom, stretch your legs. Please go ahead. Thank you.
Tornado, National Weather.
If I could please have some quiet. Thank you. The applicant has indicated that they would like to admit and exhibit the map. I'm going to allow them to introduce the exhibit for the record and identify.
Members of the board, we've marked as applicant's exhibit A1 a map of the township and adjoining area, and we had previously had several of those seeking standing mark on the map their locations. We would like to admit this map into the record.
I just want to confirm that there's a scale. It's 1 inch equals 2,000 feet, so it looks like it is the scale. At least it's supposed to be the scale.
Is there any objection to admission of applicant's A1 being a map of the proposed water supply site and the township and some surrounding townships? Any objection? No objection. Applicant A1 is admitted.
Mr. Weston, is it in the application, is it the same as Webster, or do you have extra copies?
We do not have extra copies of this with the dots on it.
Oh, okay.
But without the dots?
This is similar to a map that's in one of the truck studies, one of the traffic studies.
We would just ask that any documents that you're marking that you provide us with a copy.
If the court reporter will allow us to take this copy back, we will make a copy with those dots on it.
That'd be great. Thank you.
Members of the board, I'm submitting a motion for recusal of zoning hearing board member Frank O'Donnell. I'm not going to read the entire motion, but I want to explain the background. Yesterday, by email from the solicitor of the zoning hearing board, we received a copy of a letter which was authored by Mr. O'Donnell after Nestle Waters North America had announced its project, but before the zoning application had been submitted to Eldred Township. When we saw the letter, we were surprised. The letter expressed, and this particular letter was addressed to the members of the Blue Mountain Preservation Association, expressed a bias and prejudice against the project,
Specifically in that letter, Mr. O'Donnell referred to the Nestle project as this latest Eldred nuisance and stated his belief, quote, "There is a good possibility this extraction could dry up homeowners' wells since no one knows the location of aquifers." Subsequently, he notes in the letter, quote, "There is always a money-hungry corporation out there with no environmental conscience that is ready to rape the mountain and creek," end quote. Based on principles of due process, judicial and quasi-judicial bodies such as a zoning hearing board are obligated to avoid actual bias and conflicts of interest, or even appearance of bias and prejudice with respect to matters coming before them. Pennsylvania Supreme Court in the Horn versus Hillman Township case said, and I quote, "A governmental body charged with certain decision-making functions must avoid the appearance of even possible prejudice, be it be it from its members or from those who advise it or represent parties before it." In Thornbury Township Board of Supervisors versus WDD, the Commonwealth Court reflected the same point, that administrative tribunals must be unbiased and must avoid even the appearance of bias to be in accordance with the principles of due process. In the cases that we've cited, and we would commend to your reading, in the Piccolella versus Lycoming County Zoning Hearing Board case and the Chrisman versus Zoning Hearing Board of Township of Windsor, due process requires that a zoning hearing board member should recuse him or herself where evidence of record demonstrates bias, prejudice, capricious disbelief, or prejudgment. And recusal of a zoning hearing board member is warranted where a member of the tribunal publicly expresses predisposition under the tests enunciated by Commonwealth Court in those cases, even where a member of a tribunal, such as a zoning hearing board, has no pecuniary interest, that is, no financial interest in the matter. That member should be recused if they publicly express predisposition regarding a matter coming before them. In this proceeding, we assumed before yesterday that all members of the zoning hearing board, being cognizant of their duties, would come to this proceeding unbiased and prepared to listen to all of the evidence presented both by the applicant and those opposed to the application, and then render their judgment based on the facts presented before this board. Upon seeing the letter, however, we've come to question that assumption. And with all respect to Mr. O'Donnell and the fact he certainly has the right to express his views as a member of the public at any time, when it comes to being a member of a zoning hearing board to express a position on an application that will be coming before it, it was very clear that a special exception application would be coming before this board. In the fashion that it was expressed, we believe it expresses very specific bias. To call the project, specifically this project, a nuisance, to refer to a conclusion that there's a good possibility that it would extract and dry up homeowner wells, and then to refer to the applicant as a money-hungry corporation, indicates bias. And for that reason, respectfully, we move to recuse Frank O'Donnell as a member of this board for this proceeding.
Thank you, Mr. Weston. May I have the exhibit?
Yes. I should add, we received this letter yesterday. We prepared the motion this morning and did try to send it to both the zoning hearing board solicitor and to the township solicitor by noon today, which we accomplished. We understand that the zoning hearing board solicitor did not receive that because he was in court today. And should it be desired that the parties look to the cases that we reviewed and make a determination on that, we would understand their need to evaluate it.
The time was short not because we waited to file, but we were not aware of this letter until we received it yesterday.
Thank you, and I would just then, are you moving, you've obviously then filed the motion, and it has been marked as applicant's exhibit A2. Are you moving for admission of the motion for recusal of zoning hearing board member Frank O'Donnell?
Yes, I am moving for admission of that. Although I believe since it's a pleading, I'm not sure you move for admission of a pleading.
So, all right, well, we're gonna have it, we have it marked anyway, the motion for recusal. I don't know if you have, whether you have any comment at this point on the motion. I mean, and just to give you a sense of my take on this, based on this motion, I was gonna ask some questions of Mr. O'Donnell with respect to this matter. If you want to say anything before I ask those questions, you certainly can say that. Otherwise, once I ask the questions, certainly then the applicant can ask questions, and you as well can ask questions of Mr. O'Donnell.
I'll just make a brief opening statement, so to speak. Thank you, Mr. Martinez, board. With all due respect, and actually let me just say, we also just received this today. I am not going to opine on the law in here, as I had not had a chance to fully research it. I would ask that if you want to consider the law, that we be given an opportunity to brief it for you. But on the facts, I believe that the applicant has taken great liberties with what this letter actually says. And I do not read it nearly the same way as the applicant. I believe, and this letter, I think it's worth noting, was written in September of 2015, and at the time, Mr. O'Donnell merely opines that there's a possibility that the extraction could dry up homeowners' wells. I think even the applicant would have to concede that that was a possibility, or else why were we doing pump tests in October and November to see what the impacts were on the wells? And in fact, I think what the evidence will show is that we did in fact find there were impacts on wells. I read this to say that a drying up of the wells would be a nuisance. I don't think that can really be disputed. I think if the wells were dried up, it would in fact be a nuisance. So I don't read there to be anything, any type of predisposition in that kind of statement. I will also note, and this will be my last comment, that the comment regarding, and this again is that the Blue Mountain Preservation Association cannot rest on its laurels because there are always money hungry corporations out there, was a totally separate paragraph, a totally separate thought, and in no way was directed at the applicant. And I think it's a misreading of the letter to say otherwise. Thank you.
Unfortunately, would delay the meeting, although, you know, I understand that you have certain feelings, but we obviously want to move forward. Mr. Patterson, do you have any comments at this point? Okay. So Mr. O'Donnell, and we'll share the microphone back and forth. I have a couple questions for you with respect to this motion for recusal. First, attached to the motion is what's been marked Exhibit A, and that is attached to the motion for recusal, which is applicant's Exhibit A2. And I'll just ask you to please take a look at that letter dated September 15th, or September 10th, 2015. And did you draft that letter?
Yes.
Okay. Sorry. Did you draft that letter?
I did.
And is that your signature that appears at the bottom?
It is.
Now, with respect to this letter, are you still a member of the Blue Mountain Preservation Association?
I am.
And in what capacity are you a member?
A member and a president.
Okay, so you are still the member of the Blue Mountain Preservation Association?
Yes. Yes.
Now, with respect to this issue of the application of Nestle for a special exception, do you have any financial interest personally in the outcome of whether or not the special exception is granted?
Absolutely none.
Does the Blue Mountain Preservation Association have any financial interest in the outcome of this application of Nestle for special exception?
Absolutely none.
Now, it was pointed out that you made reference to the application, and you indicated that Blue Mountain Preservation Association will not be involved in this latest Eldred nuisance since it is out of our sphere of expertise. Have you reached a conclusion with respect to the application for special exception by Nestle?
No conclusion whatsoever.
Do you have a decision one way or another whether or not the application by Nestle for special exception should be granted?
I have no exception to that. I cannot say one way or another.
Okay, so you're saying at this point you don't have any decision at this point whether or not it should be granted?
No.
Can you be fair and impartial with respect to hearing the evidence introduced by the applicant and the evidence introduced by the township and any objectors and reaching a decision on the special exception application?
Absolutely.
I'm going to now hand the microphone over to the applicant.
Mr. O'Donnell, in your letter, you referred to the project as the latest Eldred nuisance. What did you mean by that term, sir?
Here, Mr. West.
I'm going to get to the question.
Here, let me. You guys can.
My objection is I believe the question, although you're obviously allowed to ask a leading question, is a mischaracterization of what the letter says. I do not believe that the letter is referring to the project as a nuisance. I think the letter speaks for itself.
I would just ask Mr. Weston that you please confine your questions to the verbatim language of the letter.
Mr. O'Donnell, if you look to your letter, please. And you look to the last sentence of the second paragraph, where you say that BMPA will not be involved in this latest Eldred nuisance. Were you referring to the Nestle project?
That statement came from the newspaper. And it basically is directed what the newspaper said.
Which newspaper, sir?
This was the Pocono Record.
They used the term latest Eldred nuisance, sir?
They called it a nuisance. I said latest Eldred nuisance.
And so you took the position that it was a nuisance, or not?
According to this, yes and no. Because I have no idea what the outcome of this might be.
What did you mean, however, sir, by the phrase latest Eldred nuisance?
Like I said, that came from the newspaper. So, it's just a copy.
Did you quote the newspaper here or cite
Well,
to
it
it?
doesn't say that I quoted it, but that's where I got it from.
And when you further refer to, in the sentence above, I should say rather than further,
in the sentence above when you refer to the good possibility this extraction could dry up homeowners' wells. Had you consulted with anyone in making that statement?
No one.
So you just made that statement?
That's my statement. I consulted no one.
I'm not going to proceed with further questions. I think it's fairly obvious what this individual wrote and said, and we'll stand on the motion we made. If the parties would like to file briefs about what the law is on this subject, I can well understand that. But I believe that the facts about what was said and under the circumstances are fairly clear.
Nothing further.
Board has no questions? Supervisors? Would the township or Mr. Patterson like an opportunity to ask any questions of Mr. O'Donnell with respect to the motion for recusal? Do you have any questions, sir? Mr. Patterson? Okay. With respect to an opportunity to file any legal documentation in taking a position on this issue, would you like the opportunity to be able to brief this issue?
Mr. Martinez, we could submit, we could certainly submit a brief prior to the next hearing on this matter.
Would it be your intention to do so? I guess, let me just ask you, is it your position, do you agree that there is an appearance of impropriety or that Mr. O'Donnell should recuse himself, or are you opposed to the motion?
Mr. Martinez, as I stated previously, we oppose the motion, and we do not believe there's any appearance of impropriety. We do not believe, and I believe the testimony is clear, that there is no predisposition. We believe the statements made in September were merely stating a possibility of something that could be. And in fact, I think that was what everyone questioned could be, and that's why pump tests were done and various other things were done, and frankly, that's why we're here tonight. So I don't see any bias or predisposition.
All right, so at this point, what we'll do is the applicant has filed the motion, has attached as exhibit Mr. O'Donnell's letter, and has cited some case law. I'm going to give an opportunity to the attorneys for the township and to Mr. Preston, I'm sorry, along with any other objectors. However, essentially at this point, it's a legal determination as to whether or not Mr. O'Donnell should recuse himself. So what we're going to do is, towards the end of this meeting, we're going to discuss additional dates. We'll pick the next date for us to reconvene the hearing, and prior to that reconvening of the hearing, then the attorneys for the township are going to submit some case law in support of their argument as to why Mr. O'Donnell should not recuse himself. And then there will be a ruling prior to the subsequent hearing on that issue.
Mr. Martinez, we would suggest you set a schedule for the submission of a brief by the township and for a reply by the applicant, so that you have those well in advance of your next meeting.
Well, let me just say, we're going to pick, towards the end of this hearing, we're going to pick the next date. I would then ask that the reply brief by the applicant essentially is going to be your brief. I would ask that they both be submitted within 48 hours of the hearing date. Okay, so if the township wants to submit a brief, they do so before 48 hours, and I would ask that you to provide, and obviously case law is fine. We're not, you know.
Mr. Martinez, just, I don't want to get bogged down in all the procedural issues. I don't know, I mean, a brief's already been filed by the applicant. I don't think there's any need for them to file another brief, nor do I think in a situation like this, a reply is warranted. I think we have their brief, we can file a response, and I think that should be the end of the pleadings.
Well, as far as that's concerned, I mean, the applicant filed a motion and cited case law within the motion. Certainly, I'll give the applicant an opportunity to provide additional case law, and the township will have an opportunity to provide case law. And again, that'll be 48 hours prior to the next hearing date.
I used to live briefly.
We're now at 9 o'clock. The applicant, as far as giving some type of introductory statements, overview of the project. My idea at this point is we're going to have to select at least one more date, if not several, so that everybody here knows what dates we're talking about. Now, the municipal building will be posted. Mr. Helm has indicated that he posted here as well, and so we will post facilities. As far as advertising in the newspaper, that's problematic because by the time you run the ad, depending on the date of the hearing, you may not see the ad. Not that that's what you rely on for the notice. So it will be announced at this proceeding, it will be posted at the municipal building, and it will be posted at the subject property. Okay? So we're going to have to pick a few dates for that. It's already 9 o'clock. And certainly I do want to reserve some time for public comment at the end. If the applicant thinks that they can work with 45 minutes to an hour of a general presentation of the overview of the project, or whatever you choose.
Thank you. Mr. Martinez, do I understand that the alternate members of the zoning hearing board are also here? Okay, I just wanted to make sure, since we do have that one pending motion, we have the full group here.
And I will state for the record, obviously, that the seated board currently is Frank O'Donnell, Albert Almack, and Charles Ogle, and also present are Bruce George and Annette Heist. They're alternate members. They will be present at the meetings. They were here at the beginning. They have heard all of the testimony this evening so far and will participate fully in the proceeding in the event the appointment of an alternate is necessary for future forum issues and or rendering a decision.
Thank you. First, again, introduce myself. I'm Tim Weston, counsel for Nestle Waters North America. With me tonight is my colleague Ted McFarland, representing the landowner and co-applicant Gower Estates LLC, Mark Wolf, and his colleague Robert Kidwell. The project before you is submitted by Nestle Waters North America and Gower Estates. It is an application for a special exception zoning approval for a proposed water extraction use on properties currently owned by Gower Estates within the Commercial C zoning district east of Chestnut Ridge Drive, which is a state road. The proposed project involves solely the withdrawal and transport of spring water to an off-site water bottling facility. No bottling or other manufacturing operations will occur on the Gower Estates site. Section 404, page IV-11 of the Eldred Township zoning ordinance adopted in May 2014 allows for water extraction within the commercial zoning district as a special exception subject to review and approval before this board. The application before you is significant in volume and substantive content. It seeks to address a myriad of standards and requirements in the zoning ordinance. The application comprises 3 binder volumes and an associated set of site plans for which, for purposes of this hearing, we have labeled with exhibit number stickers to facilitate easy reference
to the subparts of the application being discussed. We have prepared in advance a list of exhibits for use tonight and probably for the next hearing as well. And we have, for those who already have copies of the application, pre-prepared stickers that they can put on each one of the subsections of the application to follow along for easy reference. Addressing the zoning ordinance's requirements for content, the application includes the application form, a project narrative, which explains the means by which the project meets the standards of the ordinance, going section by section through the ordinance, an affidavit pursuant to zoning ordinance section 701B, a proof of equitable ownership and the memorandum of option agreement by which Nestle Waters acquired its interest in the Gower Estates property, a series of site plans, an erosion sedimentation control plan, a post-construction stormwater management plan, an environmental impact statement, a sound level assessment prepared by Epsilon Associates, a hydrogeologic report prepared by EarthRes Group, a wetland delineation report, a traffic impact report, and a number of other studies. Over what we expect will be several hearings, we will present each of the elements of the application with testimony from those individuals who prepared the respective elements of the report. Each of the professionals and experts who contributed to the application, and there were a number of them, will be before you and available for you to ask questions. The overview of the application and discussion of its various engineering aspects will be provided by Edward Davis, who we'll start with tonight. There will be a presentation by Lou Vittorio, professional geologist, on the hydrogeologic studies found in Volume 2 at a future hearing. There will be a presentation of the traffic study results by Earl Armitage of Panoni, the results of the sound level impact evaluations by Rob O'Neill of Epsilon Associates, and there will be a series of other presentations on a variety of topics in the application. As explained in our state's Commonwealth Court's decision of Bray versus Zoning Board of Adjustment in 1980, special exception is a conditionally permitted use allowed by the governing body of the municipality if specifically listed standards are met. The judgment as to whether those standards are met is to be made by the zoning hearing board. As explained in Shema versus Pelham Township Zoning Hearing Board, a Commonwealth Court case in 1994, a special exception is not an exception to the zoning ordinance. It's a use permitted conditionally, the application for which is to be granted or denied by the zoning hearing board pursuant to express standards and criteria. Where a particular use is allowed in a zone by special exception, it is presumed that the local legislative body has already determined that such use satisfies local concerns for general health, safety, and welfare, and that such use comports with the intent of the ordinance. Thus, once an applicant meets the specific standards set forth in the zoning ordinance, it's presumed the use is consistent with promotion of health, safety, and welfare, and the burden shifts to other parties to show the contrary. Nestle intends to fulfill its obligation and burden of proof in demonstrating that the proposed project, designed and operated as described in the application, meets all of the objective standards for obtaining a special exception zoning approval as set forth in your zoning ordinance. Beyond that, we hope and intend to show that the project can and will be operated in a manner which is consistent with promotion and protection of the community's health, safety, and welfare. We are aware that a number of concerns and questions have been raised concerning this application. Nestle Waters takes those concerns seriously. Irrespective of the discussions we've just had regarding who may or may not have standing, in a legal sense, we intend to address the concerns raised by members of the community regarding water withdrawal impacts, traffic, safety, noise, protection of natural resources, and other impacts. We know there are strongly held views by some in the community on some or all of these issues. However, we would ask that all involved not only express those questions, but also listen, as we are committed to listen. The municipality's planning code commands that applications be judged on the facts, and that the role of the zoning hearing board is to listen to and evaluate the facts relevant to the application before you. To facilitate this process, we prepared a list of exhibits which we would intend to introduce at this session, and have pre-marked all of the exhibits with exhibit numbers. We will in future sessions do the same and keep that list up to date as we go through the hearing as additional exhibits are identified. For those who previously received distributed copies of the application, we brought additional sets of stickers so they can be used, as I said before. And in response to comments received from the Hanover Engineering dated February 19th, 2016, which is last week, Nestle Waters engineers have updated some of the plan sheets in response to requests for clarifying information, and will be presenting those sheets tonight and in future hearings. So if I could, at this point, call our first witness, which is Eldred Davis. Mr. Davis?
You do solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you.
Mr. Davis, I'm going to ask you to stand behind the other microphone. And before any member of the audience can say it, please speak up.
I will do my very best.
Mr. Davis, would you state your full name?
Edward E. Davis.
And what is your place of employment, Mr. Davis?
Miller Brothers Construction, Schuylkill Haven, Pennsylvania. It's at 950 East Main Street.
And what's your position with that firm?
The Director of Engineering.
What has been your role with respect to the project, sir?
I have prepared the site plans for the special exception application. I've also assisted in the narrative that went along with the site plans. There's an environmental impact study that I participated in as well. It's also involved in the stormwater design, erosion sediment control design, floodplain work, all the civil engineering aspects of the project.
Mr. Davis, I'm showing you an exhibit marked NWNA 11 and ask you to please identify.
That is my resume.
And can you briefly explain to the board what is your educational background?
Bachelor of Science in Civil Engineering.
And from what university?
University of South Florida in Tampa.
In what year?
1984.
What's been your experience in project development and planning?
I've been civil engineer my entire career, I guess for over 30 years now, doing civil engineering work on projects similar to this, land development engineering, stormwater design for land development projects.
About how many projects have you worked on in the nature of land development and design over your career?
Over 100, I'm sure.
Your curriculum vitae indicates that you are a professional engineer. Can you explain what's required to qualify as a professional engineer?
To become a licensed professional engineer, you have to have a engineering degree from a an accredited college. That's typically a 4-year or 5-year degree. You have to also pass they call an engineering intern exam. It's an 8-hour exam that you take after you graduate. You have to work under a professional engineer for 4 years. And then you apply to take a professional engineering exam after you get references from engineers that you've worked under. And you have to take another exam, basically in the practicing field. And if you pass that, you can become licensed, or you are licensed.
And when were you licensed in the Commonwealth of Pennsylvania as a registered professional engineer?
In 1989, I believe.
Have you previously provided expert testimony before any tribunals?
Yes, many times.
And can you give some examples of those?
Done projects similar to this one over the years. Done a lot of projects with zoning hearing boards, doing zoning variances for projects such as student housing projects, parking variances. Yeah, I prepared a list of them, but it's varied over the years. There's been conditional use applications as well in front of zoning hearing boards or supervisors.
And on about how many occasions have you been qualified as an expert witness in the field of engineering and planning?
Probably a good dozen in Pennsylvania.
At this point, pursuant to the rules of evidence, Rule 702, we would request that the board recognize this witness as qualified as an expert witness in the field of civil engineering.
Township have any questions?
Just very briefly, Mr. Martinez, thank you. I see from your resume, there are a number of water-related projects that you've been involved in. Is that right, Mr. Davis?
Yes, sir.
Do any of those projects involve, or were any of those projects for water withdrawals?
Yes.
Was the bulk spring water loading facility for a water withdrawal?
The bulk spring water facilities that I've listed in here they're all for the land development side of those projects. At those times, I don't know that there were withdrawal applications in place because I wouldn't have been doing those applications.
So they were for the land development aspect, not for the water withdrawal aspect?
Yes, my end has been on the civil land development side.
So you have not been involved, other than this project that we're here, that's proposed here, in any water withdrawal projects with regard to the water withdrawal?
I was involved in a project in Schuylkill County where there was a water withdrawal project. It's not listed on this application. I did the site engineering on that as well, and there was water withdrawal involved in that one.
But you weren't involved in the water withdrawal aspect, correct?
I don't do the hydro applications for that. I do the civil engineering.
Okay. So other than this project, you haven't been involved in the design of any water withdrawal?
I don't design the water withdrawal aspects of the projects. I do the civil engineering side of the project for the land development.
And other than this project, there's only been one other project that's involved water withdrawal that you've been involved in?
I've been involved in many projects over the years related to water withdrawal, but I am doing the civil engineering side of them. I'm not doing the water withdrawal side of the application. I hope that's clear.
Thank you.
Mr. Preston?
He designs the road in the truck out.
Mr. Davis, good evening. Quite a bit of information on here. Just a quick question. You cite in several instances to a bulk spring water loading facility.
That's correct.
What is that?
That is a facility similar to this one, where trucks enter a site, pull in adjacent to a building, and load spring water in a tanker truck and take it to a bottling plant. It's very similar to this project.
Okay, so it has, in addition to the water extraction, there's also additional facilities involved for the loading of the spring water, is that correct?
Sure, you have to have the driveways, the buildings, pumps, tanks, everything that's associated with a spring water withdrawal and bulk water loading facility.
Okay, nothing, that's it, thank you.
Now, for those of you who have been granted, your request for entry of appearance has been granted, this, for example, would be an opportunity where you would have an opportunity to ask questions, okay? Those questions would be limited solely to the question of Mr. Davis's expertise as an expert civil engineer in land development. So, do any of you have any questions in addition to what has already been asked with respect to whether or not he is an expert in the field of civil engineering and land development? Yes, sir.
My question is simply this.
We can't hear you. If you have a question, unfortunately, we'll have to work on the sound system here and get more microphones. But at this point, if you need to ask or speak, it'll have to be on the microphone so it's on the record. Yes, sir.
I remember his name, but tell him to give the name.
And if you could please state your name before you speak, and then speak loudly.
I'm Dr. Baker, Raymond Baker. I live in Kunkletown, and I'm a medical physician. The question is simply this: what was the topography of the site that you are discussing?
At this point, questions will be limited solely to his qualifications as an expert.
Well, he's talking about that facility, though, this one that he's involved in.
Right. Okay.
Well, you can't.
No, you can ask him about a specific site if it goes towards his qualifications or his expertise on a particular site.
If the question is about that particular site,
That was similar to this. The site that you were mentioning, that's similar to this, you said. How similar? We have what I consider to be an unusual set of country roads here that lead out of this facility that's proposed, going through Kunkletown and up and around some curves. Was it similar to this?
Several of them have been similar to this in rural in nature.
Rural.
I'm just trying to help you. I know you're a smart guy.
Thank you. Does anybody else, again, and the questions would be, I see your hand, sir. If you have a question, you need to come forward so that you can speak into the microphone. And again, it would be limited solely to the issue of this gentleman's expertise to be admitted as an expert in the field of engineering. Again, if you want to speak, you have to come forward. The microphone is here.
Nope.
Now, let me just say, before we get a long line, because obviously you can see that this could take quite a while, his expertise as an engineer in the field of civil engineering land development has been laid out by the applicant. The township has had an opportunity to ask questions with respect to his qualifications. He does have a curriculum vitae here, his resume, and Mr. Preston had an opportunity to ask questions. Frankly, from what I've heard so far, I believe the board will be inclined to admit him as an expert in the field with respect to engineering and land development. He then would have the opportunity to actually testify about the land development project, and that testimony would also be subject to cross-examination. So if you have concerns about the project, you would not ask those questions now, you would ask those once we get to that. If you could state your name for the record.
Yes, E.J. Colento. Just a quick question here, I think, just to make sure we have a definition very, very clear. Would you consider the term water extraction and water withdrawal to be the same term? is there a technical difference between water withdrawal and water extraction?
I'm not a hydrogeologist. That would be a question better asked
Okay, well then,
to the hydro.
fair enough. Then I would say, so would this be an accurate statement as to the civil engineering work you've done on this project? A project description that says a water extraction use consisting of 2 production boreholes, underground water lines, a truck loading building, 2 water storage silos, which a silo and a tank are the same thing, paved driveways and parking, stormwater facilities, and other appurances. See attached application narrative.
Yes, I helped write that.
Then would this statement also be accurate? A facility immediately adjacent to a water body or stream that typically contains a submerged suction line, pumps, water main, multiple hydrants, truck loading and staging area, and water tanks, and which stores water on a temporary basis that is intended to be transported by vehicle to another site. Would that be a fair and accurate accounting of what the proposed facility is?
It sounds very similar.
No, I asked you a specific question.
Could we actually show him the language you're reading?
Yes, I will read the exact language. A water withdrawal facility. A facility immediately adjacent to a water body or stream that typically contains a submerged suction line, pumps, water main, multiple hydrants, truck loading and staging area, and water storage tanks, and which stores water on a temporary basis that is intended to be transported by vehicle to another site. Is that an accurate statement saying what the project description is?
Hold on a second, Mr. Wolf, do you have an objection?
Yeah, we have an objection. This doesn't go to his credentials or his...
It does go to his credentials. I'm asking a specific statement, and engineers should be able to answer that question.
Mr. Kleintop, if I could just stop you there, let's allow Mr. Wolf to phrase his objection fully.
The objection is that it doesn't go to his credentials, training, or experience. It goes to a specific question, a specific pigeonhole, but not to his training or expertise in the field in which he's been identified.
Okay, well then the project description, you have now
Mr.
said...
Kleintop.
No, hold on.
No,
This is fair.
Mr. Kleintop,
I just need to qualify.
hold on a second. I speak.
Okay.
Now, with respect to your questions, they go directly to his qualifications as an engineer.
Correct.
If you could please indicate to me, it seems that you're reading some definition and asking him whether or not that definition fits in with the proposed project.
I asked the question, however, project description, the engineer has now stated that he helped write the project description.
Yes.
And I asked him if water extraction and if extraction and withdrawal were the same thing, and he said effectively yes. That's fair. I'm done.
Okay. All right. Any other questions with respect to Mr. Davis's qualifications as an expert? Yes, sir. If you could please state your name.
My name's Robert Bush. Mr. Davis, as an expert engineer with the credentials that you have you ever designed a facility that was smack dab in the middle of a village like this? I know you mentioned rural. Well, rural to me is out in the road. You don't pass the house for maybe a quarter of a half a mile or a mile apart people live. But it's right smack in the village where we pass numerous houses. Have you ever designed a facility in an area like that before?
Several facilities that I designed have been rural in nature, and yes, they pass houses, they make turns similar to this one. Have I been able to see a community with like this directly from the facility? No.
Well, the other issue I have is you as a licensed engineer, and you did your job, and you did it well as far as building the building. But doesn't your license also include the human side? For example, look what's happening to the people and the property owners here. Don't you have a responsibility to say something about that? I mean, you know, you are a professional. You have standards. I hope you're a man of character and everything else. You're cutting taxpayers off right here, you and Mr. Nestle, right at the knees.
I'm going to object. This doesn't go to his qualifications. They go to his...
He certainly does. He's either a man of character or he's not. Most people, you know, have a conscience. I don't know where you people have yours.
Thank you, Mr. Bush. At this point, and I appreciate the sentiments of Mr. Bush, but with respect to Mr. Davis's qualifications as an expert, we will admit him as an expert. I would just ask Mr. Weston that you define the field with which you want him to be qualified. An expert in the field of...
I'll restate it based on his curriculum vitae. An expert in the field of civil engineering and land development and stormwater and related issues. Okay, I'll go stormwater and erosion sedimentation control issues.
Mr. Martinez, I don't have an objection to the I don't have an objection to the civil engineering and land development. I don't believe that the testimony or the qualifications got us into stormwater erosion, E&S erosion and sedimentation. Again, if I think all the discussions up until the final recitation had been civil engineering and land development.
If there's a question on that, let's get it out. Mr. Davis, have you prepared erosion sedimentation control plans for any projects?
Yes.
Approximately how many have you done?
Probably 100.
Have you prepared any stormwater management plans for projects?
Yes.
Approximately how many?
More than 100.
Have you ever testified as an expert in the field of erosion sedimentation control and stormwater with respect to the projects you've designed?
Yes.
In what kind of proceedings?
Similar proceedings as this.
Do you have any questions?
Davis, I don't mean to belabor this point. I'm trying to find on your CV where the reference to these many erosion, sedimentation, and stormwater projects are. Can you identify them for me?
I would say every one of the projects listed under land development and subdivision projects all had erosion and sediment control and stormwater design associated with them, each one of them.
And you were the lead stormwater and erosion sedimentation engineer on those?
I was lead or I oversaw that on each one of these projects. I was responsible for them.
Well, and how many of these that are listed here did you actually do the stormwater and erosion sedimentation versus overseeing?
Probably 2/3 of them or more.
Thank you.
Mr. Preston, any questions?
I do not have any.
Any further questions? Is there any objection to Mr. Davis being... Yes, sir.
Question.
Come forward. I'm sorry, it's the microphone issue. And sir, if I could just ask you to state your name, speak loudly in the microphone, and we're addressing the issue of Mr. Davis's qualifications as an expert.
My name is Charles Phillips. We're questioning your qualifications as an expert. As an expert, are you familiar and can you quote the PA Floodplain Management Act 1978-166, 60.3D.
Can I quote the act?
Are you very familiar with it, and can you quote what it says?
I can't quote the act. I've surely been involved in floodplain management ordinances. I've been involved in the FEMA maps, and I understand them, and I work with them quite frequently.
You're familiar with the issues then?
Sure.
Section 2.02.
Can you read that section to me?
Well, I don't have it in front of me, but the question is, has the floodplain administrator issued a permit for floodplain development in this situation?
For this project?
Yes.
Not as of yet. It has not been submitted for his review yet.
Then you're not familiar with the act, because the administration must review prior to the permit.
I'm aware of that.
Section 3.03B. And it also prohibits drilling or moving any earth or fill before you have that permit, which I understand has been done. You have drilled test bores, holes, this, that, and the other.
How did you get credentials?
Again, the questions here should be limited to his qualifications as an expert. We will get into the land development plan, what testing is done, and what tests will be done. But at this point, you asked him whether he was familiar with the PA Floodplain Management Act and other stormwater acts and that sort of thing. He indicated he is familiar with those, although unable to quote them.
Do you always follow their directions, what they tell you to do?
We're obligated to follow ordinances like that in municipalities that we work in.
Okay, that answers it.
All right, are there any other questions with respect to his qualifications as an expert? Okay. Does the township have any objection to Mr. Davis being admitted as an expert in the field of civil engineering, land development, erosion sediment control, and stormwater design and no. There being no objection, he is admitted as an expert in that field.
Mr. Davis, in preparing your aspects of the special exception zoning application, what township ordinances did you consider?
The zoning ordinance, Eldred Township zoning ordinance, their subdivision and land development ordinance. They have a stormwater management ordinance and a floodplain ordinance. I believe that's all of them.
I'm going to show you an exhibit marked NWNA1 and ask you to please identify it.
Exhibit NWNA1 is the Eldred Township zoning ordinance, compilation 2015.
And does that include the zoning ordinance as adopted in May of 2014?
Yes, it does.
And is this the zoning ordinance that was in place at the time that the zoning application was submitted by Nestle Waters North America?
Yes.
I'm showing you exhibit NWNA 1A and ask you to please identify it.
This is the official zoning map for Eldred Township.
And is this the zoning map that was in place at the time that Nestle Waters North America submitted the application, which is the subject of these hearings?
Yes, it was.
I'm showing you document marked NWNA 2 and ask you to please identify it.
This document is the Eldred Township Subdivision and Land Development Ordinance.
And did you refer to the subdivision and land development ordinance provisions that were cross-referenced in the zoning ordinance when you prepared your application?
Yes, I did.
Showing you exhibit NWNA 3 and ask you to please identify it.
This exhibit is the Eldred Township Stormwater Management Ordinance of 2007.
And I'm showing you NWNA 4. And ask you to please identify it.
This exhibit 4 is the Eldred Township Floodplain Management Ordinance of 2013. Ordinance number 2013-1.
Do those exhibits, exhibit NWNA 1, 2, 3, and 4, reflect the ordinances that you initially said you considered?
Yes.
The initially said you considered in developing the application?
Yes.
I'd like you now to identify the application.
Before we get
Leave extra copies if anyone needs one. I'm showing you the exhibit marked NWNA 5 and ask you to please identify it.
This is the special exception zoning application for the Deer Park Chestnut Springs project, volume 1 of 3.
Showing you the exhibit marked NWNA 6 and ask you to please identify it.
It's a special exception zoning application for Deer Park Chestnut Springs project, volume 2 of 3.
I'm showing you the exhibit marked NWNA 7 and ask you to please identify.
This is the special exception zoning application for Deer Park Chestnut Springs project, volume 3 of 3.
Mr. Martinez, and I know this is premature, and we can cover it when we move these documents into admission, into evidence, but I believe that there is an issue with regard to NWNA 5 to the extent that it contains the bog turtle study and the review letter, as those were not originally submitted as part of the application and were submitted subsequently after the application went to the planning commission. And we're going to have an objection to that. I know, again, it's premature at this point, but I want to make a note for the record, and we can cover it at the time of entry of the exhibits into evidence.
Thank you.
Likewise, with regard to the zoning ordinance that's been submitted, as Mr. Preston noted at the beginning, there's an open legal question that is before the courts on whether the zoning ordinance provisions that are particular to this project are void because of a question that's been raised over the procedure of their adoption. So while we understand the the document in and of itself is something that the applicant's resting on. We just need to note that there's an open legal question on that.
Mr. Davis, with respect to an issue which the township's special solicitor has raised, in Exhibit E of the environmental impact statement in Volume 1, which is NWNA 5, as a result of comments that were made by, I believe, Hanover Engineering, was it identified that there were several letters that were, several documents that had not been included in that exhibit?
That's correct.
And were those subsequently submitted to the township?
Yes.
And I ask you to identify ask the court reporter to mark this as 5-A, NWNA 5-A.
As a point of order, can I have a copy of what we're talking about here? What about the rest of
I believe that Mr. Preston is asking for a copy of the binders.
Well, the exhibits that you
And we will make an extra set of binders for Mr. Preston, who entered his appearance today, and we will provide them before the next hearing.
when?
As soon as we can produce them.
Well, you're introducing stuff into evidence. You certainly didn't think there was one copy would be sufficient, or 2 copies, I hope.
We brought 3 copies.
Well, I have to look at this stuff to prepare for the next hearing.
I believe that you will have it at least 2 to 3 weeks before the next hearing. Understanding, if I understand correctly, the next hearing being towards the end of March.
We'll discuss the next hearing date.
You don't have a copy, but I can take your copy, you can make one for yourself.
We have a copy already. We'll let Mr. Preston take ours, and we'll take the second set when you have those made.
I appreciate that, thank you.
Just a point of order, Mr. Martinez, that I
Oh, sorry, there's a flash flood warning. It can't turn off. Yeah. I tried to.
point of order on the volume 1, although we've now identified certain documents separately, I believe they're still contained within the binder, and I would ask they be removed from the binder as they were not submitted as part of the binder.
Mr. Ziegler, the exhibit as it's described in the binder actually refers to the document. Unfortunately, the attachment wasn't duplicated properly in that exhibit, although it's referred to. And we sent the materials to the township last week, noting the fact that those 2 documents were inadvertently missed in the as attachments to the exhibit, and we brought extra copies here. Those, as I understand it, the Planning Commission is still deliberating on its review of the application. They have a copy of that, and they have had it since last week.
As a point of clarification, are we talking about the volume 1 of 3, being NWNA Exhibit 5, being supplemented with NWNA Exhibit 5A? It's 5A, what's in question here? in that
Correct,
binder?
but within 5 presently, 5A is within 5 already. So now we've got 2 5As, one that's within 5 that shouldn't be in there, one that's within 5 that shouldn't be in there, and the separate 5A, which...
And so your objection is that the binder, Exhibit 5, Volume 1 of 3, which is individually represented by NWA 5A, is not the original document that was submitted with the application.
Correct.
Okay. And so then, am I correct in understanding from the applicant that you have supplemented your application with respect to NWNA 5A being the Phase 2 bog turtle presence / absence surveys?
The document you have that is 5A consists of the bog turtle survey, the Phase 2 bog turtle survey, and the resulting letter from the U.S. Fish and Wildlife Service, which is the last document.
So then as far as the original application and the documentation that comprises what has been supplemented with Exhibit NWNA 5A, that remains in the original application, obviously. Do you have a copy of, separated out, do you have a copy of that original section of the application?
The only difference between the original and the supplement is those 2 documents were added to the back of Exhibit E. To be clear, if someone wants to take out those 2 documents from their binder.
Could you identify for me?
Yeah, the document Phase 2 bog turtle presence absence survey and the U.S. Fish and Wildlife Service letter are part of Exhibit E to the environmental impact statement from Volume 1.
And how does Exhibit E of Volume 1 differ from 5A?
Exhibit E was to be a compendium of all responses to the Pennsylvania Natural Diversity Inventory process, including all responses from each of the agencies. 2 of the documents were missing from it. They were referenced in it, but the actual documents were missing.
Mr. Martinez, I don't want to belabor the point. The reason I'm raising the issue is we have objections with regard to the timing of these 2 documents and their submission. And I think it makes sense for the clarity of the record to have them separate and apart from the binder, and then we can deal with 5A independent of 5.
I would ask that the applicant prepare an exhibit, NWNA 5B, which then specifically identifies the 2 documents that are being added to Exhibit E, which is of Volume 1 of 3.
Well, that's 5A. That is 5A.
This entire document is a supplementation.
Right. The problem is that 5 also contains 5A, and it shouldn't.
So then Volume 1 of 3 is not representative of the application.
Correct.
We believe it is representative of the application since we referred to the letters in that exhibit. Unfortunately, they were missing the 2 copies. If the board desires that they be removed from these volumes, we will submit them separately. Those 2 letters are what they are.
Well, you referenced 2 letters, but I have a document that appears to be 25, 30 pages long.
Excuse me, it's a report and a letter. A bog turtle report and a letter. It's 2 documents.
Is the applicant capable of generating, I mean, obviously we would like what's being represented as the application to be the actual application. And if the applicant seeks to supplement the application, we can address the supplementation. But it does appear that what is currently marked as NWNA 5, being the Special Exception Zoning Application Volume 1 of 3, is actually not representative of the original application.
So that there's no confusion, we would be happy to go into the official document and take out those 2 pieces, those 2 documents that are currently put in, and separately submit them. That's no problem.
Okay, based on the redaction of the exhibit that's been presented tonight, and obviously we will redact that this evening, all right, then we can address the further exhibits.
Thank you.
Because you're not moving for admission at this time of everything. Then you're, okay, thank you. And then Mr. Weston, if I may just ask, what time?
It's a little after 5, a little after 10.
Okay. So a little after 10, how many more exhibits do you have to introduce for Mr. Davis?
He has a number of other exhibits to introduce. I think the question is how the board would like to finish the evening and how much time you would like to have, because we could go on for literally hours, and that isn't what you want to do.
So I'll ask what may be an obvious question, but are there people here that may be interested in expressing opinion with regard to this project? If so, raise your hand. All right, well, actually, I thought it would be almost unanimous, but okay, so I'm going to allow some time for that. So I think at this point, although it's somewhat ungainly to now try to attempt to redact these binders, but that's a process that we're going to have to do to make sure that these exhibits are actually what they purport to be. So we're going to have to redact the binders. We're going to have to pick some dates for future meetings, and then we'll have some public comment, okay? So at this point, I guess we'll do another brief recess to allow for redaction of the exhibits. All right, so take 5. Thank you for your indulgence. All of these exhibits and everything else, although very important, it's pretty dry stuff. But so far, quite a few exhibits have been identified. There's been an opportunity to object to the substance of some of the exhibits. But at this point, I'm going to allow Mr. Weston to identify and move for the admission of the exhibits, and then let the objectors, if they have any objections, state those on the record.
Actually, Mr. Martinez, I was going to wait until the witness who was here had walked through all of the application and all the parts of the application before I moved its submission, so we can postpone that aspect and save a little time.
All right, great. And then so we'll leave that, so we have the exhibits that have been identified, not moving to admit those yet. I just want to state on the record, as far as the next dates, as you can imagine, scheduling with everybody to find availability is difficult, but we have agreed upon March 30th and April 20th. Wednesday evening, 7 p.m. And again, that will be posted at the municipal building. The property will be posted by the zoning officer, and it'll be posted here. If you have a question, you have to come forward to the microphone. So the next dates are Wednesday, March 30th at 7 p.m. and April 20th at 7 p.m.
I have a question of our experts.
For that, you're going to have to wait until he's back.
That would be March 30th.
This is just very short. It pertains to his
presentation here, just this little bit. 2 or 3 small questions.
He's not here. I mean,
This gentleman, the engineer.
Right, he's already been qualified as an expert. He's identified some exhibits. The applicant isn't offering any more testimony this evening.
We'll be back with him. He will be back.
This is referring to just dates of being first, first of all, employed by Nestle or a subsidiary.
Right, any question, he's already been admitted as an expert. With respect to any testimony, his testimony will resume on March 30th.
So I have to wait?
Yes.
No, okay.
Yeah, unfortunately. Okay, so at this point, I appreciate all of you coming out, obviously, and this is an important issue to all of you, and it's important to the board to analyze this thoroughly, okay? When I indicate to you that I would open the floor to public comment, there's a difference between comment and evidence, okay? So certainly your concerns or your opinions, you can express those. You'll have an opportunity, and I would ask that we start that now. But I just want you to know that this is not evidence. It's not weighed by the board. What the board will take into account is the evidence introduced on the record, which is initially going to start with the exhibits, etc., and then the Board of Supervisors have their attorneys who will introduce evidence, as well as the objectors will introduce evidence. And all of that evidence, once collected, will be the body of evidence that's taken into account in arriving at the findings of facts and the decision and recommendation of the board. But certainly, your feelings or concerns are important, and I would like at this point to give you the opportunity, one at a time, to express briefly your concerns. And obviously, a lot of the concerns are well water, drying up of the aquifer, truck traffic, degradation of the roads. These are all things that the applicant, in the presentation of their evidence, are going to have to put on evidence and establish how and why, what effect these things will have, and to what extent it'll have an impact on the community. So as far as all of these issues, they will be addressed by the applicant. They will be addressed by the representatives of the township through cross-examination and introduction of evidence. But certainly, if you just want to briefly speak about the issue or express your opinion, now would be the time. Obviously, I would ask that you please keep it civil, keep your comments brief, and if somebody said essentially what you were thinking, well, we heard it, so you don't need to say it again. I don't mean to be rude, but obviously we have lots of people and not enough time to hear from everybody. Okay, so if you just want to kind of line up and come forward and say something with respect to this project, if you're feeling on the matter, now would be the time to do that. So from that, then.
I think this gentleman.
Yes, sir. Okay.
Yes, my question is to...
No, sir, I need if you could take the microphone so we have it for the record.
Hi, Don Denaro. My question is to the state hydrologist. Is there a state hydrologist there?
There's no cross-examination or questioning of witnesses until they actually testify. And then there will be an opportunity to cross-examine.
When are we going to qualify the state hydrologist? This is a hydrology project.
Right. As I've indicated, there's 2 upcoming dates, March 30th and April 20th. If Mr. Weston knows at this time tentatively who he will have testifying on those dates, you will then have an idea, a preview of what's to come on the 30th and the 20th.
Depending on how long the testimony takes on the 30th, I would hope to have Mr. Davis's testimony completed that day. There is a short testimony on some stormwater calculations, and then I would believe that Mr. Lubatorio, the hydrogeologist, would be put on. So that would probably occur at the April 20th hearing. But that depends on how fast this process goes and how many questions are asked of Mr. Davis on cross-examination.
Good. I would like to postpone my question till then. permission, please?
Yes, well, the time for your questions will be once the witness has testified on direct. So we will see you on the 30th, and probably with respect to that witness on April 20th.
All right.
All right. Okay. So at this point, does everybody feel comfortable with the proceeding and does not wish to make any statements or address the board with respect to this matter? Yes, ma'am.
I just wanted to make a statement.
You need to come forward, please, and speak into the microphone. And if you could please just state your name and keep your voice up.
My name is Patrice Junta, Zone 2, 35 years. I live adjacent to the Buckwa Creek, as well as the aquifer that's connected to the project site. I just compiled a bunch of research with pretty good citational authority, and I wanted to just quickly state a few things that I had discovered.
Ms. Junta, I'm sorry. If I can...
No.
All right. You've been allowed, and I understand this is a very complicated procedure, and I hate to keep interrupting people, but if you've been admitted as an objector, you will have an opportunity to introduce evidence. So,
Not necessarily evidence, it's just actually observations.
okay,
You said
okay,
commentary,
right,
so I'm
which is
saying
fine, and then
commentary.
if indeed you wanted to submit evidence to the board to consider in the application, that would come at another time, but if, okay,
understood.
yep, thank you, and I'm sorry.
No, I fully understand that. I want to be
Yes,
on base.
Mr. Wolf.
My recollection is this person is a party, and I think public comment should not be made by parties. They're subject to cross-examination. I think there's a distinction between a party and someone expressing an opinion.
Is that a legal statute?
I think there's a distinct, and again, I apologize for all the legal aspects of this, but again, like I said, as far as if you have standing as a party, you can cross-examine witnesses and you can introduce evidence. That unfortunately is going to be several hearings down the road once we get there. So it's a matter of introducing evidence. We will do it at the appropriate time. If it's
Commentary.
if it's a brief commentary, then that's fine.
Okay, thank you. I have multiple concerns, but just a quick synopsis is in terms of baseline studies which haven't been done. This is quoted, this is referenced, and it alleges baseline and time-dependent hydrological and hydroecological studies are necessary to address and monitor the effect of groundwater use on local freshwater bodies, ecosystems, and geomorphology. To guarantee sustainability, these studies should accompany planned groundwater development. A contaminated aquifer cannot be used as a resource anymore. Therefore, every effort should be taken to ensure that both groundwater quantity and quality are preserved for the benefit of future and present generations. That's all I have right now.
Thank you.
Thank you.
Thank you. Does anybody else have? Yes, sir.
I have a question about his employment. He was talking about.
Again, any questions for Mr. Davis? We'll have to take those up at the next hearing when he again takes the stand.
It's alleged that he was employed by Nestle or a subsidiary, right?
We'll address that. You'll have an opportunity to cross-examine him once he's finished his testimony on direct by the applicant. So procedurally, the witness testifies, the township would have an opportunity to cross-examine, Mr. Preston would have an opportunity to cross-examine, and then we would go through the objectors who have standing, and those parties would be given an opportunity to cross-examine the witness.
So we're taking as a fact that he was employed by Nestle, but it had to happen on a certain date.
Your statements of his employment, things like that, those would have to be addressed at the time of cross-examination. Okay.
In Jay Kleintop. This is just a procedural issue for future meetings. To be clear, the next meeting, the zoning hearing board reconvenes on March 30th. Is that correct?
That's correct.
With a subsequent meeting scheduled for April 20th, correct?
Correct.
Okay, for people who are township residents, since this did not end this meeting tonight, will there be, do they have the opportunity to enter in an appearance for other township residents that were not able to make tonight's meeting? So will there, at the beginning of the meeting, if someone were to come in and want to put in an entry for appearance application and sign in, and upon your cross-examination were found to be suitable, would they be allowed to enter in?
I would not, they would be allowed to fill out the application, submit the application. It would then be subject to analysis.
Okay, so they can enter in though, provided that they are found to be acceptable. Okay, thank you.
I have a question.
Yes, sir. You can just state your name.
Yeah, my name is Rocco Michaels, and I'm a resident here in Kunkletown. And I'm just wondering how this circle, I mean, it appears to me this mile, or I don't, basically what I'm trying to say is that because of the water, we're all connected here. And also because of the traffic, I live in Kingswood Lakes, and our lake is right on Silver Spring. And we actually had an accident. We almost had a really bad accident with a kid who ran out to the street. I'm very concerned about cars, not even cars, specifically trucks, but I'm not allowed to testify because I'm not in this circle. But it appears that this circle has been conducted by Nestle on their dollar, and I'm just wondering why water supply that runs downstream and affects everybody in this town that's on wells, why it's just basically an adjacent neighbors and such.
I think unfortunately what happens is that there's certain legal restrictions on who has standing, and that comes down to whether you would be impacted by this development. Now, obviously, if you draw on the same aquifer, if you're an adjoining property, there are many factors that could grant you standing. However, if you're removed from the development site area, then there becomes the question of whether you are actually impacted by it. And I know it sounds difficult, but for example, if a truck leaves the site and it drives 3 miles, yes, it drives past your house. And if it continues to drive another 10 miles on top of that, it's going to drive past my house. But I don't have standing. Because lots of trucks drive past my house.
But we're taxpayers that pay for these roads. You know,
I understand. Absolutely, I understand.
we paid for this infrastructure. They're coming in and using it.
Absolutely, and that's why there's hearings, and that's why you have a township and a zoning hearing board that will take evidence. The applicant will be held to comply with all requirements, whether they be in the subdivision land development ordinance, whether it be PennDOT. There are all types of regulatory agencies. There are all types of ordinances that address this type of development. And you can see by the size of the application so far and the exhibits that are being submitted that there are any number of experts who have reviewed the ordinances and are taking every step they can to comply with all of these ordinances. Now, the applicant is going to put on evidence to hopefully establish full compliance with all ordinances and laws of the Commonwealth and regulations of the Commonwealth. And that's why the Board of Supervisors has attorneys here. They will cross-examine their experts. They'll cross-examine their witnesses. They'll have an opportunity to review every one of these documents to make sure that they are in compliance with all of the rules and regulations that have been promulgated by townships and by other state agencies whose very task is to make sure that the roads are safe, that the roads aren't degraded, that the aquifer is safe, that water is not polluted. I mean, it's a big balance. I mean, obviously, you need this is America, there is business, but there is also individual rights and there are property rights. And this is a big balance, there are regulations. And that's what this process is all about, making sure that all of the regulations in place are being addressed by the applicant and they're being held to the standard. I mean, that's what the township is for, that's what these attorneys are for, and that's what the people who have entered their appearance as parties are for. They're here to challenge the evidence and to submit their own evidence to show why or why not this application should be granted. So you'll see as you attend these hearings and as you get an opportunity to review some of this evidence and see what the proposed project is, you start seeing exactly what it is and what the impact is going to be. But again, ultimately, with respect to roads and things like that, obviously there are many agencies who have an interest. PennDOT has an interest in maintaining its roads and not having them excessively degraded, okay? Whether they weigh in on it or not, you know, but there are quite a few regulations and quite a few concerns. They're all concerns that people in general have, all right?
I just have a real quick technical question. I'll try to make it loud, but who came up with this circle of plus or, it just seems to be no rules to this circle of people. Who made up this circle thing? Who made up who can be?
As far as your question of who made up this circle thing, it's in regard to a proximity to the development site and whether or not one has standing.
But I mean, where did that come from? Is it a law or where did that come from?
Obviously no law is exact, but yes, as a general principle, to determine one's impact as a result of a development project, you can look into their proximity to the development site. The closer you are, the greater the likelihood of impact. And it also depends on the nature of the development.
But I mean, who physically came up with this?
There is no hard and fast rule.
But I mean, who actually brought this? I mean, where did this come from?
This map and this exhibit has been introduced by the applicant, and so they have
So it was paid for by Nestle.
which is just being used as a general guide to see where people live. But as far as, you know, there's no hard and fast rule of where you are and whether you have standing or not. I mean, obviously, it would help that you're in the township, and the closer you are, the more likely it is that you have standing. But that's why we had an opportunity to ask questions, why there was an opportunity to cross-examine some of the individuals who wanted standing. As far as admitting people and accepting their status as a party, it was quite liberal at this point because we don't have all of the evidence as to who is directly impacted. So I think almost everybody who wanted to enter their appearance as a party was granted that pending further determination with respect to the aquifer, who will be impacted if there were to be a negative impact. All of these things that we don't have any evidence on yet. So once we gather further evidence and once we see exactly what the project will entail and we see who will be impacted, we'll have a better idea. But there's no hard and fast rule.
So is that enrollment process, is it ongoing? So like next meeting someone could possibly?
This is where this was announced, okay? This is the hearing date, this is the initial hearing. It's been published, it's been advertised. So essentially at this point, no, we're not going to go through a continuing process.
Because before coming here, I thought I was exempt, but now I'm feeling I possibly might be part of it. So I think that's just kind of false advertising.
Well, your comment is noted, sir.
Okay.
And I appreciate your comment.
Thank you.
Does anybody else have any other comments? Yes, sir. Again, you'd have to step forward and state your name. I'm sorry, sir, with the camera, could you just state your name for the record?
Yeah, Rocco Michaels.
Rocco Michaels?
Yep.
Thank you, sir.
My name is Vernon Morley, and while we're looking at maps, I think that the map that really is significant that should be developed and be developed very accurately is to have the Zone 1 shown and exactly whose property is being impacted and how. And for Zone 2, I'm referring to the wellheads. That should be on there because while you're talking about impact, that is very significant. And if somebody wants to use their property, it shouldn't have to be up to the applicant at that time. I mean, the property owner at that time, to determine, is it prohibited? Is it a special exception? What is it? I think that's the responsibility of the applicant to accurately show that circle, the 400 feet, who's impacted, and the half mile, who's impacted. That's very significant. Thank you.
Yes, thank you. I believe that Mr. Weston indicated, correct me if I'm wrong, that they will have an expert testifying with respect to the aquifer and exactly identifying the perimeter of that and what properties or what area would be impacted by that.
I'm not talking aquifer, I'm talking about use of the property now. I'm talking about use. 960 acres surrounds them pretty much. I want to know what can I do? For example, anyone in Eldred Township, if they want to put a heat, what do they call it now?
Geothermal heat pump.
Geothermal. They have to go for a special exception. And I don't care where you live. That's in the zoning ordinance. So people should know how they're impacted. I want to know, how is my property impacted in that 400 feet? In other words, what can I do? There's certain things I can't do at all. There are like 15 uses that really impact my property because of those two zones. I want to know how far reaching they are. So that when I go to get a permit, it's not up to me to determine where am I located in this impact zone. That's significant.
And so if I'm understanding you, your question is with regard to the zoning ordinance and what's allowed in these zones.
Use of the property.
Yes, and so those would be in maps of the township. The township has delineated certain zones which are covered by ordinances and then allow certain uses as special exceptions.
And they should be responsible to show whose property is impacted. Then you can look at the uses and see what it's doing to your property.
Well, the applicant will identify the development site and the aquifer. As part of that, the township, the applicant's job is to show where their site development plan is, where the aquifer is, the impact on the aquifer. The township maps need to reflect what areas are zoned what and what can occur in what area.
But they're the ones who are impacting everyone's property. So they should be responsible for the cost of that. That's going to be costly. They should be responsible to show who is impacted. Mr.
Well, I'm sorry to interrupt you, but that's what this whole process is for. They are presenting information and testimony as to a site development plan in an area that's going to be developed.
I have one parcel at 64 acres. I want to put a house on it. Or I want to do some activity that requires the 400 feet or the half mile.
Right.
Is the applicant, the property owner responsible to go and have a surveyor come in to measure that?
Yes.
That's ridiculous.
If you want to do any development, obviously you have to go see your friendly neighborhood zoning officer and talk to the township.
You're missing the point, sir. The point is, their activity is impacting everyone's property. So they are really throwing another expense onto the individual property owners. You have to determine how far is this half mile? If I live above the church, is that within the half mile? Who determines that?
We have. Yes.
Zoning ordinance classifies.
I'm sorry.
No, go ahead.
The zoning ordinance classifies zone 1, 2, 3. And all he's asking for is a map, so he doesn't have to pay the survey. Where does 1 start and end? Where does 2 start and end? And where does 3 start and end? Well, 3 is the whole township. But 2 and 3 need to be clearly, am I right, Vernon?
Yes.
2 and 3 need to be on a map.
1 and 2.
Or 1 and 2, I'm sorry.
1 and 2.
Because our ordinance, specifies wellhead protection as zone 1 and zone 2 and zone 3.
It's it's not shown on the map.
And it's not shown on the map.
Well, then, and I appreciate it, and that's what exactly this is for. So that's an issue. Certainly the attorneys for the township have heard you, and where exactly this will impact and the zoning areas, those issues will be addressed.
That was my question. You were saying where do you live? You know, if somebody says maybe it's a half a mile, they don't know. When they want to do something, it's going to be an extra burden for them to prove that they're not within that half mile of impact.
Right, and that's why we're here for this process, and that's why we're going to take the testimony, and that's why we're going to review this application. Yes, Mr. West.
Mr. Martinez, during the course of the testimony by the hydrogeologist, we will have such a map that shows the wellhead protection areas.
Okay, and then I would just ask each of the parties, for the record, as I indicated before, at the close of collecting evidence for these proceedings, the board has to issue a decision, finds the fact, within 45 days. If we're going to adjourn to the 30th of March and then April 20th, obviously I would ask that the applicant, both of the attorneys for the applicant, as well as the township and Mr. Preston, and people who have entered their appearance, that you waive the time requirements as set forth in the municipal planning code and the ordinance with respect to that 45-day timeline and the other time requirements of the board, such that it would enable us to actually adjourn this. If we can't, if our feet are held to the fire and we have to comply with the 45 days, then obviously we can't have a hearing.
The 100 days to get your cases. The other element of it, Mr. Martinez, is the 100 days for each party to get their case in. And I think that's what we need the waiver for.
And Mr. Martinez, I think both the township and we agree that there will need to be a more extended period than the 100 days on each side. We need to, I think, talk about how each party, how many witnesses they have. We understand the need. This is a complicated matter, and everybody needs to have their chance to put their evidence in. So I think it would be good for us to have a discussion about how much we need to do and set up an appropriate schedule. And then I think at the end of all of this process, I'm even looking far ahead towards the end of this hearing process, you may want to have the parties prepare proposed findings of fact or conclusions of law or briefs or something that will be of assistance. And if that's desired, then we need to talk about the time frame for doing that. But I think that's something the council can have as a discussion between now and the next hearing or after the next hearing.
So with respect to, and specifically with respect to then the time requirements of submitting your evidence, and then obviously the board submitting any decision based on that, do you specifically waive those time requirements for the purpose of adjourning the meeting and presenting additional testimony?
I think the question is, at the appropriate time, if we know what the schedule is for parties to submit findings of fact and conclusions of law, and then there would be a time frame thereafter for the board to render a decision. I'm not prepared to sort of in blanket waive all the dates, but I think we can come up with a schedule that makes sense for the board and for the parties and is fair to all.
I'm just solely speaking about now, we are adjourning to March 30th, and then we've also agreed to adjourn to April 20th. All right? So as far as concluding the hearing for this evening, I'm just solely asking.
My understanding is that the 45-day rule applies at the end of all hearings,
yes,
not at the end of each session.
Yes.
So there's no waiver needed.
Well,
we're certainly not concluding the testimony at this point.
Right. So to the extent that you concur on the record with an adjournment and a continuation of hearing and collection of evidence on the 30th of March and the 20th of April, you concur with that adjournment and subsequent hearings on this issue on those dates?
Oh, absolutely.
Okay. Additional evidence.
On those 2 dates.
The township concurs.
If the township concurs, and then Mr. President? right. Does anybody here who has been granted status of a party object to us adjourning this to the 30th of March and then April 20th for the purposes of continuing the hearing and collecting additional evidence? Do not see any hands. Does anybody object? Okay, great. Thank you. So at this point, we'll generate another notice. We'll post it on the township building. The next hearing will be March 30th at 7 o'clock. At that time, we'll resume with testimony with respect to the exhibits and then the land development plan. Thank you.